So
Nobody wants to do it. Yeah, I mean, I think actually a little.
Morning, Commissioner LePage.
Sure.
Can you hear us?
She would like to.
Me?
Yes.
Yes, I can.
Oh, good.
I can hear you.
Excellent. All right, well, I think it's 9 o'clock, so we should get this train on the rails. Welcome to the November 30th meeting of the Commission on Maine Commission on Governmental Ethics and Election Practices. We'll start with agenda item 1, which is ratification of the minutes of the September 28th and October 26th meetings. Does anybody have a motion regarding the September 28th meeting?
I move we adopt the final draft number 3 of the minutes of September 28th.
Is there a second?
Second.
Terrific. Is there any discussion? All right, since we're partly remote, we'll take a roll call vote. Commissioner LeClaire?
Yes.
Commissioner Hastings? Yes. Commissioner Marvel?
Yes.
Commissioner Newman?
Yes.
And I'll also vote yes. Is there a motion on the October 26th meeting?
I'll move that we accept the October 26th.
Terrific. Is there a second?
I'll second.
Is there any discussion? Okay, we'll do a roll call vote again. Commissioner LeClaire?
Yes.
Commissioner Hastings?
Yes.
Commissioner Marvel?
Yes.
Commissioner Newman?
Yes.
And I'll also vote yes. October 26th minutes are accepted as printed. Our next agenda item is a rulemaking public hearing, and we discussed some of these rule changes at an earlier meeting. And so I'd like to convene this hearing to accept public comment from anybody who might be here and interested in making a comment on these proposed rule changes. Is there anyone here who has an opinion that they'd like to share? Yes, please. Come up to the table there.
Okay.
Yep. And introduce yourself.
Good morning, Commissioners. My name's Sean Roderick. I'm here on behalf of the Maine Senate Republican Campaign Committee this morning,
Terrific,
and that's my comments will reflect that.
terrific.
The part of the rules I'd like to address is the part when it comes to qualifying period for replacement candidates to collect $5 contributions. I think that's on the second page, well, on the paper I have the second page qualifying. So
It's the 94-270, chapter 3, section 2, paragraph 4N.
ETH 5.
On ETH
yeah, I
5.
think you have different pages.
Oh, okay, I'm sorry.
Okay, no worries, no worries. So our viewpoint is that this we agree with this a rule change when it comes to this. A candidate currently when it comes to seed money, a candidate can start collecting that when they register, but they can't start collecting $5 checks until they become the official candidate. And under how the current system works, it could be a couple weeks before a caucus is called because these committees are run by volunteers and stuff. So candidates are losing time.
I want to before you go on, I want to make sure that we're looking at the right rule.
Section 9.
I think we're talking about section 9. Right? Okay. Is that correct? The one that's
It's
on the last page of this
Well, on the one I have, it's the second date. I don't think we're looking at. the document.
And is death, withdrawal, or disqualification of a candidate during campaign, is that section?
Qualifying period for the placement candidates. It's,
Yes, that's right, 2A. Qualified periods for this.
Yep.
Okay, I think we're.
Right, because you're talking about the,
in July.
yep, good, thank
Okay.
you.
No problem. So they can start collecting, it could be up for a couple weeks and they can be delayed. Because in a primary, for example, you can collect checks. We have candidates who collect checks for the supplemental rounds after the June primary. And they may not ever use those because they may not win the primary. In some cases, we just come over with a big envelope and give them to Aaron and say, here you go, or Emma, or when the registrar and say, here you go. In some cases, the candidates send them back to folks. And I see something like this in this process, a couple weeks is there's a lot of time to collect checks that may not be able to happen. It would be helpful to candidates because, people come up to them and say they want to help. And I want to donate $5. They try to write their name down and they may never see them again. And I think it would be helpful if this one was changed.
So what would you specifically, what would your recommendation be to change the language?
A recommendation that candidates could collect $5 during as soon as they register with the commission as a candidate, just like they can collect seed money. And then some type of rule to allow for the return. Either they can return those $5 contributions or they can give them to the Clean Elections Fund. Similar to what's done now if they over collect. Or if they, as I said in that example of the June 14th primary, some people are great at it, go out and collect all 535. And then they get maybe 6 or 7. Some people collect 600 or 700. We got a couple candidates, one that collected over 700, and then she ended up returning those or just giving them to the commission in some cases, which you.
Are there any questions from commissioners? From Mr. Roderick? Commissioner Leclerc, any questions?
do you have any specific suggested language?
I could work on some and offer that.
That's a great idea.
Yeah, Jonathan had sent me an email, was nice enough to send me an email about this rule change, and we had talked about it a while ago, and
Terrific.
had a lot going on, so I'm happy to draft some up and get that to the board deadline.
That would be great. Thank you, Commissioner Leclerc. That's a great idea. Jonathan, do you have any questions or comments?
No, just as background, we had written the rule in a general way to state that the commission could establish a qualifying period that would give staff the discretion to set a period, but another alternative, if you're persuaded to do that, is to actually specify what period is. And that sounds like Mr. Roderick wants to move in that direction. So that'll be before you in December.
Yep, great.
Yeah.
Mr. Bolton, do you have any comments or thoughts?
No, I don't. I think Mr. Wayne expressed it well.
Terrific. Thank you very much. We
Thank
appreciate
you.
the input.
Thank you for your time.
Thank you. Is there anybody else here who's interested in commenting on the proposed rule changes? Okay, then I'll close this portion of the hearing, and I think there's still a period for public comment, but those will be taken by written comments, right?
Yep, through December 11th.
Yep. Okay, let's move on to agenda item 3, which is a request for an independent expenditure determination from the Poliquin campaign. Mr. Wayne, would you like to kind of brief us on this?
Sure. This is another request by the Bruce Poliquin for Congress Committee that the costs of a television ad were not independent expenditures in support of Paul LePage. And Mr. LePage, as is well known, was a candidate for governor. And there was some 2-second footage of Mr. Poliquin and Mr. LePage walking together in this ad, but Mr. LePage wasn't mentioned by name, and his candidacy was not mentioned. So from the staff's point of view, there's very little promotion of Paul LePage, and we would recommend a determination that either this is not an expenditure or the costs were not incurred to the intent to influence the election, or however you want to formulate it.
Sure. Yeah. Any questions for from commissioners for Mr. Wayne? Commissioner Leclerc.
Is this the same ad that we were, I know it's a different report, maybe a different buy, but is it essentially the same footage that we reviewed last time?
It's a different ad, but I believe the footage, the 2-second shot is the same footage that appeared in an earlier ad.
Thank you.
Is there anyone here who would like to address this on behalf of the Poliquin campaign?
Just briefly, I certainly agree with the commission's staff's recommendations, but a suggested change going forward on these type of expenditures and reports. I would prefer to see commission staff make the determination and then having somebody who doesn't like that decision appeal. It just seems there's a lot of paperwork generated and appearances, and I think we could eliminate that by designating that the executive director could make that call.
I think that's a really interesting thought. Is that something we could pursue through a rule change, do you think? Or would it take a statutory change?
You're looking to.
I'm waiting. No, I didn't want to preempt Mr. Bolton's point of view on this, so I'll just hang tight for a second.
Yeah, let's give me 1 second here to review the language of the statute.
We like to keep Mr. Bolton awake.
You recall too, the history of sort of the accelerated reporting on independent expenditures. I mean, there's a public interest in having speedy, transparent reports. I completely accept that, but but the policy that was being advanced was with matching funds in clean election campaigns is whether an independent expenditure or whether some communication triggered the need for the match in a state senator, state house, or gubernatorial campaign.
I do remember that history. Commissioner Hastings.
The whole thing, we always did. Deal with these well after the ads are on. Commission, well, they run the ad, but they gotta run the ad.
Right.
So the whole system is kind of backwards. It's just been. All our decisions are after the fact and everyone has to take their chances.
But I think your idea is a good one. It might serve the public's interest a lot better to have a swifter decision, and then, you know, if the decision needs to be revisited, then we can do that.
And that would work publicly posted.
Yeah, right.
So looking at the statute, I think it talks about the commission making a determination by preponderance of the evidence. I think the best way to, if this were going to be a process where staff makes the determination and there's an appeal process, probably writing that into the statute would be the better way to do that, because I think is drafted now, it contemplates a proceeding like this.
Yeah.
So, you know, maybe that's something that, you know, staff could consider in terms of, or the commission could consider in terms of an agency bill, you know, adding to the agency bill maybe going in this session, but that would probably be my recommendation, is the better way to pursue that.
Terrific. Great. Thank you for the suggestion. So, is there more discussion amongst commissioners on this question of whether this advertisement was an independent expenditure? Please.
I move that the commission find that the TV ad expenditure in this case is not an independent expenditure.
Is there a second to that motion?
I second that.
Is there any discussion on the motion? Okay, we'll proceed to a vote. The motion is that this was not an independent expenditure. Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Marvel. Yes. Commissioner Newman,
Yes.
and I'll also vote yes. The next agenda item is the complaint and the finding, the commission's finding last month against the American Leadership Committee Maine CAT. Jonathan, would you like to give us some background?
Sure. We want to make sure that council is on the
Yeah, for sure.
call.
Oh, okay, let's wait a second then.
Expected new guest. Her name is Sally.
and I'm just not sure which item she's on.
She's on the next item, I think.
She is, okay.
Welcome, folks. Can you both hear me?
Yes.
Terrific. Would you please introduce yourselves again?
Despite the name showing on my Zoom, which is that of my daughter, for which I apologize.
We won't expect her to attend.
She's at school. My name is John Burkhan, and I'm a lawyer at the Elias Law Group.
Hi, and I'm Emily Hogan, also a lawyer at the Elias Law Group.
Would you say your last name again, ma'am?
Yes, it is. Despite the spelling, it is pronounced Hogan.
Okay, great. Terrific. Thank you very much, and I appreciate your attending. I'm going to ask Mr. Wayne for a brief summary of what's been going on with this issue.
So this was from your last meeting, and the commission determined that the American Leadership Committee Maine PAC had violated Maine's disclaimer statute because it had distributed mailings and digital ads that did not contain any information about the top funders of the organization that was responsible for the ad. And the commission deferred any consideration of enforcement action until this meeting. And the other decision that was made at your last meeting was about the compliance of an independent expenditure report. The PAC had filed a report on October 14th, and in the amount of $18,146 for 10 mailings. And the commission determined at your last meeting that it did not comply with our independent expenditure statute. And the issue there was whether the reported date of the expenditure, October 12th, was correct or not. And that the correctness of that date determines whether the report was on time or not. So since your last meeting, the PAC submitted a letter on November 16th with attachments, and that was included in the meeting packet. So you've had a chance to look at that. And the PAC is urging you to waive the penalty because after your last meeting, it moved forward with correcting any the disclaimers on the future independent expenditure communications, and for other reasons as well about how the law is confusing and so forth. They are here to probably to highlight some of those points and to answer any questions you have, and possibly to respond to the staff memo. We had offered you a perspective on one possible outcome, but the commission has wide discretion on whether to take any enforcement action and how much it should be. We also included in the packet comments from one of the complainants who's here today, and also written comments from Mr. William Clardy, who is one of the candidates in the races that was affected by this. So staff's happy to answer any questions along the way as you can see.
Sure. Does any of the commissioners have questions for Mr. Wayne at this point? Okay, terrific. Is there, Ms. Pettengill, is there anybody else who'd like to speak on behalf of the proponents?
Thank
Welcome.
you, Chairman Schneider. Thank you.
Please introduce yourself and tell us what you'd like to.
So my name is Kim Pettengill. I did file one of the original complaints. Although I do a lot of volunteer work with the Republican Party, in this instance, I filed this without the benefit of their permission, perhaps, although I did tell them I was doing it, but I did it as an individual. A number of candidates around the state, in fact, had mailers opposing them, and we all know the disclaimer originally said there was no top donor. Mr. Wayne, I felt, was very clear in his instructions during the previous hearing that the proper way to rectify this situation would be to say that the donor was the GLCC and the top 3 donors are. in this instance, while they did tweak their disclaimer, certainly, they still never mentioned the DLCC. And they continued for a number of days to run YouTube videos. They appeared on Facebook. They had not changed the disclaimer for at least 5 days. I am not technologically adept enough, but my understanding is they could quickly have paused those YouTube videos and had that changed instead of continuing to have them run. With Mr. Wayne's email, I had an opportunity. I did submit some additional information. I have since then found out that while they did in fact tweak the disclaimers for the opposition ad, they never tweaked the disclaimers for the ads supporting the Democrat candidates within these same 24 districts. But I didn't get that till after the deadline, and I did not further do it. My comment is this. I found out this morning that in fact, previously there was a finding against one of the Republican organizations for improper information during another campaign period. And as I said before, I think we all need to follow the law and follow the rules. And I think that I don't care which side it is. I don't care if it's the Republicans. I don't care if it's the Democrats. We need to follow the rules as they are, and we need to be held accountable for that. We should all know, we should be careful about what we put out and how we do it and make sure that we do everything appropriately. And I think the fact that Mr. Wayne took the time to actually tell them what they should put in the disclaimer, and they still did not do what he told them to do at the last hearing is somewhat disrespectful. And I hope that when you are making your determination about how to go forward with this, you will take that into consideration.
Thank you very much.
Thank you.
Well, let me see if any of the commissioners have questions. Any of the commissioners have questions for this? Okay, terrific. Thank you very much.
Thank you.
Are there any other proponents? Yes, please. Please have a seat and introduce yourself and let us share your information with us.
Yeah, my name is William Clardy. I'm the candidate that Mr. Wayne referred to. And yeah, I'm the base of some of the folks that got hit by the ad campaign. So I've got a bit of a personal interest in getting addressed. I apologize for my voice, which saved you guys from a whole bunch of speaking time. But I'm going to try to stick to a couple of real brief points. One is that, there's two reasons for imposing the fine. One is pure punishment, which is, I think that's what I'd like to see being occasionally vindictive. The other is education. And for education, that means it has to be big enough that they pay attention and they actually apply the lesson. And that takes me to my other point, which looking at some of the filings that came back from the ALC, where they were very nicely showing where they had changed the disclaimer language. I was also noticing that on 3 of their digital ad campaigns, they show drop dates of October 3rd. Now, I used to work in publishing. I know you can have an ad piece mocked up 99% done and just throw a photo and a name in there with the split. Digital production, there's production costs, time to arrange for studio, scenery, filming, whatever you're doing. So if those ad campaigns were dropping on the 3rd, then why are they being reported as initial expenses in the October 3rd independent expenditure filing rather than Ms. Heather, the treasurer, going back and correcting those filing dates as well? That tells me the lesson didn't quite sink in, which means they need to get a bit more attention paid. I don't know if it would be wrong to introduce that as an additional factor in this proceeding, or if it needs to come in as a separate complaint. But I definitely want the DLCC and crew to know that this is the way we do it. Pay attention. go ahead and when they start taking affirmative action, more than just you pointed out that you made this mistake, but they go through and find a mistake or two of their own, then that's an indication that the education is sunk in. In the meantime, I suspect we're Commission's $10,000 penalty might wind up being not really much more than their cost of doing business in terms of billables for Mr. Bergheim and Ms. Hogan. And that's about all I got to voice for.
Well, thank you. Maybe there may be a question or two, so preserve a little voice for that. Any questions from commissioners for Mr. Clardy? Sir. Okay, thank you very much for your input. Is there anybody else who'd like to speak on behalf of Congress? Mr. Bergheim, would you like to address us?
Thank you so much for the opportunity to address the commission. I just wanted to start by addressing Ms. Pettengill's comment regarding the content of the disclaimer. Following the hearing, we worked in close consultation with commission staff to try to ascertain exactly what disclaimer the staff recommended that we should include on any future mail or digital communications. As the commission itself may remember from the hearing, while there was a finding of a violation, there was not a finding of exactly what disclaimer should be used. The initial staff report, we certainly understood to indicate that the disclaimer should include the top 3 donors from the account from which the funds were expended. But after the hearing, following a discussion, or as was relayed to us between staff and commissioners, the advice to us was to instead list the 3 sources that provided the highest amount of aggregate funding to the overall DLCC organization from November 4th, 2020 to the present time. So we took that advice and we followed it. And so we identified the 3 donors who needed to be included in the updated disclaimers on all of our future ads. So that just may be a difference of recollection or memory, but it is our belief certainly that we followed the advice regarding the content of the revised disclaimer to an exact T, and we did not deviate 1 iota from that advice. And so that's just kind of the first point. I just wanted to, and we went through this a little bit in our letter to the commission, but just wanted to go through the remedial efforts that the organization took following the hearing. So there was a mail flight that would have been the 4th mail flight that was sent out in Maine. It was printed on October 24th, which was a day before we received the staff analysis, and it had the no top donors disclaimer. The original plan was to mail this flight on October 26th. Once we received the staff analysis on October 25th, which was the first analysis indicating disagreement with our client's position regarding the disclaimer, ALC Maine paused distribution of that mail flight. So mail flight 4 was paused, any distribution, once we got the staff analysis. And then after the hearing, once the commission reached its conclusion, mail flight 4 was never sent. So we just completely junked an entire mail flight in order to comply with the commission's decision. The production and design costs for mail flight 4 was $20,000, $20,926.99, with an estimated additional $1,500 for printing. So that's a total expense of $22,462.99. That was essentially just a sunk cost that the committee ate in order to comply with the commission's ruling. So that's just an expense of the committee. There was then the final mail flight, which was scheduled to be printed on October 26th. Again, we put it on hold pending the outcome of the hearing. Following the hearing, ALC Maine affixed the commission prescribed disclaimer to the mailers, which we attached as an exhibit in our response. And on November 1st, ALC Maine sent this mail flight to every voter who had received any of mail flights 1 through 3. So every voter who received a mailer from ALC Maine with the no top donors disclaimer prior to the staff analysis and the hearing did in fact receive a mailer from ALC Maine that listed the top 3 funders as prescribed by the commission staff recommendation. So those were the remedial steps we took with respect to mail. With respect to digital, again, upon receiving the staff analysis on October 25th, ALC Maine paused purchase of new digital ads. Following the hearing, we took remedial steps through the different digital ad platforms in order to correct the disclaimer on ads that were already airing. We understand, and those who brought the complaint and those who are here today flagged some instances in which they or others saw an ad airing after the hearing that did not include the correct disclaimer. If that did occur, the reason for that is that each platform has different internal rules and processes that affect the immediacy of when changes can take effect. Facebook, which has been widely reported, conducts a review of political ads that can delay updates. YouTube has an unpublished daily upload limit as well. And so all of our ads had the correct disclaimer. For Facebook ads starting October 28th and 29th, the YouTube ads were correct on October 29th through November 1st. And then we also delineate the steps we took with respect to programmatic digital advertising as well. And we put together an exhibit, a very, very lengthy exhibit that lists all of ALC Maine's independent expenditures for digital ads, the disclaimer that originally appeared on the ad, the updated disclaimer, and the date the updated disclaimer appeared on the various platforms. That's our effort to demonstrate all of the steps. As you can tell, they were extensive to comply with the commission's finding in the hearing on October 26th. And so to the extent that there are complaints that certain ads did not change the disclaimer, we simply disagree with that factually. If there's evidence of that, we would obviously, be happy to review it, but that is not our understanding. And we also addressed the claim in one of the letters that, in fact, the disclaimer hadn't changed. We didn't see a timestamp, for example, on that particular ad. So Ms. Pettengill claimed, I think in her letter to the commission, that a digital video supporting a candidate ran on 11/3 at approximately 12:16 p.m. Again, that did not have the correct disclaimer. That's inconsistent with our review of the digital ad spending, and the screenshot that Ms. Pettengill included did not include a date stamp, other than to say it was uploaded 3 weeks prior to when the screenshot was taken and viewed 18 times. So we are not sure exactly how this particular ad was obtained, but it is our understanding and belief, and as we tried to demonstrate in the exhibit, that all of the digital ads were corrected as well with the correct disclaimer. Just another note as well regarding kind of the fine and the effect on the organization and our compliance. As you know, we articulated in our letter our request that the fine be waived. We understand that the staff has recommended a $10,000 fine. We take our compliance obligations very seriously. I've been working with the DLCC at least since 2010. And in my recollection, we have absolutely never had a proposed penalty that would be executed anywhere in this range for this kind of violation. This would be a significant penalty for our organization. And it is one that if that is the penalty that the commission decides to impose, one that we take very seriously, one that will cause us absolutely to, certainly in Maine, to change our approach going forward. It is something that, setting aside the particulars of the money, anytime that a regulator disagrees with our interpretation, that is not something that we take lightly. And in addition to the penalty itself, we encourage, as we said, $22,000 in sunk cost expenses and plus countless hours, man hours, women hours of our staff in order to get the disclaimer right, and from our consultants as well, obviously in addition to any legal expenses. So this has been a significant event for the organization in terms of both costs, but also in terms of, for reputational standpoint, we take a lot of pride in our compliance obligations. And this is something that clearly affects us and something that we take very seriously. And we understand the staff's position on this. And we take seriously when the staff says that, in the opinion of the commission staff, the disclaimer that we had previously been using was bound to attract negative attention and was risky. And that is a very fair comment on the original disclaimer. As we explained, this is the protocol and methodology that we use in states around the country. It is not something that we invented for Maine. It is our standard practice and operating procedure. But that obviously standing alone doesn't mean that it complies with Maine law. And we understand and respect the commission's position that in the view of the commission staff, that what we had proposed did not comply with Maine law. But it was not something that we invented to deal with Maine's disclaimer requirement. It was our standard methodology. But going forward, certainly in Maine and frankly elsewhere, we need to think through whether our standard methodology, given the particulars of the state law and the motivation behind any changes to that state law, which is apparent in Maine, whether our standard methodology will be viewed to draw negative attention, to not be consistent with the spirit of the state law, and would be considered risky. Those are fair criticisms and ones that we will incorporate in the future, not only in the state, but frankly, across the country. So that's just kind of what we wanted to offer. Happy to answer any questions that anyone may have.
Thank you, Mr. Burkott. I greatly appreciate your comments. Are there questions, comments, Commissioner Hastings?
I have one factual question, Mr. Burkott. When you ultimately identified the three top funders, did I hear you say that those were the top funders from the period of November 4th through November 21st?
From November 4th, 2020 through the date of the ad.
Is that, this whole thing of identifying top three funders is a little murky to me. They're not necessarily the top three funders then for the election cycle, but that's, I don't know. The statute really is not clear about what period you look to. Mr. Wayne, Mr. Burkott indicated that he worked with the commission, or they worked with the commission to come up with this disclaimer. Is that your understanding?
Well, very prompt. We didn't work with them to a large extent, but they were very prompt in emailing us on the afternoon of your last meeting. And they said, we want to right away start updating our disclaimers to be consistent with the commission's decision. And as Mr. Burkhan said, the commission didn't really articulate what the disclaimer should have said. And different ideas were discussed in the course of the October 20th meeting. So they were looking for our guidance on what the disclaimers, the top three donor statement or top three funder statement should say. I conferred with the council, our council, John Bolton, not with any commission members. And my advice to them, which I gave by email, was please use the top three funders of the DLCC since in this 2-year election cycle. So they are correct that they should go back to November 2020 for that approximate 2-year period and find out the three largest sources of funding to the DLCC. That was our advice, and they're saying that's what they did.
You answered my question. I was thinking it was a different November 4th, such as this year.
Oh, okay. All right. Yeah.
No, that makes all the sense in the world to me.
Okay, so it was this election cycle. That does make sense.
Okay. Yeah.
Thank you.
Any other questions or comments for Mr. Burkhan? Yes, Commissioner Leclerc.
I'm not sure I heard everything clearly, so I just want to try to get some clarification. It was my understanding when Ms. Pettengill was testifying, she mentioned that there was a I'm not sure if it was a mailing or a video or digital. Mr. Burkhan, are you saying that you're absolutely saying that's not what happened?
That is not our understanding of what happened, which we indicate in our exhibit, which includes both positive and negative ads. So if there are specifics that the commission would want us to consider there or to look at, we're happy to do it, but that is absolutely not our understanding. We did not make any distinction in our directions to revise with respect to, positive or negative ads. It was across the board.
Okay, thank you.
Any other questions or comments from commissioners? Okay, Ms. Hogan, would you like to add anything? I'm sorry, are you muted?
No, thank you. Nothing to add. Thank you.
Okay, terrific. Is there anybody else who'd like to speak on either side of the issue? Okay, so now it's left to us to determine. Yes, please. You can come forward.
I'm not on behalf of either party, but as an interest of someone's work.
Absolutely.
Add some history to this.
Of course.
So back, my name is Sean Roderick. I'm not speaking on behalf of the Senate Republican campaigns. I am clear this was speaking on behalf of myself, someone who's been involved in House and Senate politics now for about 18 years. Back in 2011, when it comes to penalties, the Republican State Leadership Committee made expenditures of about $400,000. That committee was fined $26,000 by not this commission, but by the Maine Ethics Commission. This fine this year today, if I'm reading the staff memo correctly, is about $368,000 worth of expenditures. I think for consistency, something, at that time, that was the largest fine in the state history for the commission. I mean, and when it comes to the memo of, first time working in Maine, it's tough to follow these rules. We've worked with the commission a long time. They're easy to work with. I mean, a lot of the times, unfortunately, candidates I've worked with or myself are fined for honest mistakes. Sometimes they're not honest mistakes, but a lot of times they're honest mistakes and try to comply with Maine law. And I think that's a responsibility that, the campaigns I'm involved in, we take seriously. And when folks come into Maine and want to make expenditures, I've worked with national organizations, they consult with us. I don't think not having experience is an excuse. I mean, this was a huge expense. It took a toll on some of these candidates I worked with or volunteered to work with on the House side, even though I was on the Senate side. So I just wanted to bring that history. There was a fine of about $400,000. I mean, not $400,000, but a $400,000 worth of expenditure at that time. It was a $26,000 fine. And as it said in the memo, the fines have gone up significantly. From the 2015, I know our candidates and our PACs, if we make a mistake or we've been fined quite a bit more than when I first started.
Sure,
I
thanks.
just wanted to bring that.
But before you go, let me see if anybody has any questions. Any commissioners have any questions for Mr. Rugg? Yes, Commissioner Leclerc.
I'm just wondering if you think what consideration we should give to the $22,000 worth of material that was not sent out and was waste. Do you think that should be considered by the commission when we assess this penalty?
I think zero, and I actually personally disagree. I think that should have been filed as an IE because the interpretation, like if we produce a video, the recommendation, how I've interpreted that we've been given is if we produce a commercial spot, and I actually went through some of the IEs after I read this morning. Both sides production is filed as an independent expenditure has been by both parties. And to say that you file when you pay the postage, I mean, that would mean in some cases, sometimes the postage doesn't get paid till the day the mail is dropped in the mail. So I believe that production should have been filed as an independent expenditure. My opinion. So
I think my question, I might not have been clear. I'm asking you if we should consider the financial loss that they incurred by wasting the printed material or whatever it was. I think he testified that it was about $22,000. If that should all be considered by us in assessing the penalty that they had incurred that loss in an effort to comply. After the hearing last month.
No, because, the campaigns I've worked on, we've made mistakes when we printed stuff or produced stuff and we just didn't put it out and ask for forget, we've had to eat that cost. There's been mailers and stuff that I've seen and handouts I've seen say, oh, this is missing this disclaimer and there goes $5,000. I don't, decide to distribute it and then ask for forgiveness. So I would say no.
Thank you.
Are there any other questions or comments from commissioners? Okay, thank you, Mr. Roper.
Thank you.
Is there anybody else who'd like to address us on either side before we begin deliberation? Yes, Mr. Burko.
Yeah, just so I'm able to, and I appreciate that comment. And, I'm taking this information actually from a chart that I believe Mr. Wayne had published in 2016 that listed some of the past fines that had been issued. And I think this is referring to the Republican State Leadership Committee fine of $26,000 that was assessed in early 2011. And I think there are a couple just, as the commission begins its deliberations, a couple of distinguishing factors there. The first is that 10,000 of that 26,000 was specifically assessed because the late filing of the IE report delayed payment of matching funds to 5 candidates, which is not at issue here. So that's just, I think, related to a different legal issue. And then an additional 10,000 was because a report that had been filed was simply omitting almost $75,000 in mailings. It wasn't that it was simply, there was a dispute as to the date that it should be filed, but it was actually completely missing about $75,000 in mailing. So 20 of the 26,000 that was assessed in that particular fine, I think, relates to issues that really are not present here.
Perfect, thank you. Any questions, comments from commissioners?
Not from Mr. Burcon, but I did want to ask Mr. Wayne if we have any kind of history of fines previously assessed.
We have different lists of fines that we pull out for you for different purposes. I'm marveling at Mr. Burcon's ability to come up with something that happened in 2010 and actually to assess the distinctions between that matter and this one, which is pretty amazing. So it's true that there was that event that resulted in a fine of $26,000, and that my general recollection was that there's been more and more out-of-state money being spent in Maine legislative races, and in that year 2010, the amount of money that was spent was just perceived to be very high, and the way that was reported did disadvantage the Maine Clean Election Act candidates who were the Democratic candidates who were in the Maine Clean Election Act program. They didn't receive their public campaign funds as quickly, and that was so it was those two factors resulted in what was at that time a large penalty. If I could just offer some more history,
Please.
because it predates the current membership.
Sure.
Commission. In the 2000s, for routine errors by candidates, penalties were often in the range of $150 to $200. For routine errors by PACs, the penalties were often in the range of $300 to $400. And the commission steadily got criticisms from people that the penalties were not high enough, that this is just what we would come up with as penalties were just easily absorbed. They were the cost of doing business for some of these larger campaign organizations. And the election reform advocates, who always were advocating for more disclosure and stricter enforcement, they put it as an initiative on the ballot in 2015, and that doubled the penalties. So this is sort of a global comment about this matter, but also the candidate matters that are upcoming. So the commission in April of 2018 said, look, the penalty formulas have doubled, but we haven't really responded as a commission to increase our penalties. So since 2018, there has been an overall increase in the penalties. And, for example, there was two late 24-hour reports in the context of a ballot question from 1 or 2 years ago that resulted in a $30,000 penalty. So the penalties have been going up over time. And I'm sorry, I don't have, we want to be responsive to your needs with whatever kind of data you want on penalties. It's our job to come up with it, but we've had some problems maintaining our databases, and it's always hard to know what the right format is. So we've sort of been doing it on an ad hoc basis. And I don't have any. For us, 10,000 is significant, but there certainly are higher penalties for various disclosure violations in the tens of thousands. And if you need us to pull together some more additional information, we're happy to do that.
I mean, I'll say something I'm struggling with is, we've talked about this with all kinds of issues, just trying to be consistent, as a commission, because I think that it promotes, rule following and it's hard for me to do that without more information about penalties that have been assessed and for why in the past. So for me, I think some more information would be helpful.
What do we think? Are there other commissioners who would appreciate having more information about the history of assessment of penalties? Commissioner Marvel.
Well, at the risk of rambling with not well thought out previously comments, I'm just trying to think of the general public also looking at this. Some of the depth of language just in the statutes can take us down rabbit holes at different times. I mean, I've been sitting here, I think, close to 2 years now, and still grappling at times with, is that really an IE? Or the language can be challenging at times. It needs to be descriptive, it needs to be objective, it needs to be comprehensive, and it is. The cases that come here, many of them feel familiar. Some of them are slightly different, including this one. We have a national source of influence money feeding an organization, a PAC set up strictly to operate in this state, which is basically, in my mind, a gate or a pass-through to political activity on the ground in the state. That, to me, clearly didn't take into account the absolute core of what we're all about, which is disclosure of sources of funding of activity. And so, while I'm struck by Attorney Burkon's intelligence and clarity, and I am impressed with it, I think of the organization, and I think putting out hundreds, if not thousands, of pages of print and digital materials that say no top donor screams against the intent of everything we're about. On the subject that Commissioner Newman just brought up, I feel a little bit ambiguous. I absolutely agree with what you said. I also take it as an assumption that when staff makes a suggestion to us, they are consciously pointing to history and work and precedent previously done, and are trying to take into account the fact that no two cases are identical. I'll look to staff and ask, in the last 3 years, have we had a complaint brought to the commission that closely resembles this one?
No, we actually received very few complaints about the top 3 donors statement.
Okay. So I'm going to lean towards hoping that we resolve this today rather than looking for more data to back up our reasoning.
Thank you. Appreciate it. Any other thoughts amongst commissioners about? Well, I think what I'll do is to kick off our discussion, I'll make a motion that we have 2 tasks ahead of us today. We have with this issue. We have to decide what penalty, if any, is necessary for the violation of the top 3 donor issue, and we also have to find out we have to determine what penalty, if any, is necessary for the timing issue on the filing of the independent expenditure report. And so I'd like to take those separately, and I'd like to deal first with actually the misstatement of the top 3 donor disclosure. that we found at the last meeting, and I'll make a motion that we assess a fine of $10,000. Is there a second for that?
I'll second.
Okay, so that should start our discussion about the penalty for that violation. Anybody like to weigh in? Commissioner Hastings.
Very quickly, I want to support what Commissioner Marvel just said. I think the failure to disclose, this flies in the face of the statute, and I find the reasoning of the methodology to be disingenuous in a way to avoid having to disclose donors. So I think there is a clear violation. I think that it flies in the face of the spirit of the law, and also put the $10,000. And which I think is substantial compared to what we've done in my tenure.
I agree. Any other comments or thoughts from commissioners?
I don't have anything else to add. I mean, I support the 10,000. I want some, I do think this is an egregious violation. That's a part of what I want to make sure that we're setting that example as well, for the reasons that that's after the memo. And, being the newest member of the commission, I just don't have that much of a history. So I'll support the 10,000. But I would like, I guess, in the future, maybe again, start gathering some information, because I do want to make sure that we're consistent and also inconsistent with the message. Certain violations are more egregious than others, and there should be penalized and sure, reflecting that. So
Yeah.
And it's important that we're putting out consistent information for the public.
Yep. Any other thoughts or comments in the motion? Okay, hearing none, we'll, yes, Commissioner Leclerc.
I'm sorry that you saw my hand go up at the last minute.
No.
So
If that was an involuntary motion, you don't have to say a word.
Well, can I ask a question of Director Wayne?
You may.
So and it's just, have you heard anything today that has caused you to change your recommendation of the $10,000?
Well, one of my challenges in making a penalty recommendation is I don't really know how you feel and what range, about the severity of the violation. Having heard some of the comments here today, I heard the word egregious, for example. I don't think 10,000 carries the message that this was an egregious violation. If some of you think that this is a very serious violation, I think it should be higher in the tens of thousands of dollars in order to be consistent with how you feel. That's given the amount of the spending and the size of the organization and so forth, and sort of wanting to make an impression that these laws matter. If you view it as a very serious violation, you might want to go higher than 10,000, but it's entirely in your discretion.
Thank you, Mr. Wayne. Thank you for asking the questions, Mr. Claire. Are any further comments or questions from commissioners, or would someone like to make an amendment? Okay, hearing none, we'll do a roll call vote, and the motion is to fine the ALC Maine $10,000 for their violation of the top 3 donor provisions in our law. Commissioner Claire?
No.
Commissioner Hastings?
Yes.
Commissioner Marvel?
Yes.
Commissioner Newman?
yes,
And I'll vote yes too. So the vote is 4-1 to impose a $10,000 fine. The next issue we have is the timing of the independent expenditure report. And I will make a motion to start the discussion that we assess a fine of $679.88. Is there a second?
Second.
Perfect. So now we'll discuss that. What that motion contemplates is that the decision was made certainly no later than the 10th to make this expenditure, and that would have required a report on the 12th. The actual report was filed, I think, on the 14th, making it 2 days late. Is there any other discussion amongst commissioners? questions? Okay, seeing none, we'll have a vote. Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Marvel,
Yes.
Commissioner Newman,
Yes.
and I'll also vote yes. Thank you, everybody, for helping us work through this. I appreciate both the complainants and the respondents. I think everybody did a upfront and really was very cooperative and helped us work through this. So thank you. Okay, let's move on to agenda item 5.
We're expecting Mr. Vanderhulst on behalf of the PAC to join us. So
Okay.
just wait a second.
Sure. Let's take 5 minutes just as a break, and we'll assemble the people for question 5.
All right.
And Miss Sally, I think.
Which
I have a mess, there's no storms. I love the Commissioner Leclerc and getting back here in person.
Did you hear that, Commissioner Leclerc?
Yes, and I actually have something to bring up. We're not back on the formal meeting yet, or are we?
We are.
Okay, have we moved on to the next item yet?
We're about to. We're trying to get Ms. Sally up, who is the complainant in the next matter.
Miss Sally's not expected, but Mr. Vanderhulst
Okay.
is on.
Oh, okay, terrific. Is he on by phone or is he going to be?
he's on the Zoom.
Yeah,
Yeah,
I've asked him to join. He should be on shortly.
Before we proceed, can I ask something?
Please.
Okay, if we haven't moved on to the next item yet, and I'm not sure.
We
whether-
have not.
I would like to change my vote on the last item. I was confused. So my vote on the last item would have been a yes had I not been confused.
Okay, terrific. Mr.
It
Bolton,
might
is
be
that?
2 items ago.
This has,
Is that what
you mean the $10,000 one?
Yeah, the $10,000 fine.
Yes,
You would like to vote yes on that.
I would. It's my understanding that if nobody objects to that and we haven't moved on to the next item, that I should be allowed to change my vote, but perhaps Mr. Bolton would like to weigh in on that. But in any event, I would like to just say it publicly that my vote of no was not what I intended, so.
I'm looking at Mr. Bolton.
Well, I think that's probably correct. I think what we could do, though, I could confirm that. I'd be helpful to be able to do a little research to confirm that. We can certainly record it and, in the minutes of the proceeding, and if there's a problem with it, I could make that known to commission staff when they're preparing the minutes. But I think it's probably okay.
Mr. Tardy.
Yes, just a friendly suggestion, Mr. Chair.
Yeah,
If,
sure.
somebody voting on the prevailing side for the motion could move reconsideration, wherein they, and then. it's a-
Exactly right.
I like that
Exactly
idea
right.
too.
Yeah, thank you. Thank you.
Having voted on the prevailing side on the motion to assess $10,000 fine in the preceding action matter, I move that we reconsider our.
Is there a second? Is there any discussion? Okay, we'll take a roll call vote. Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Marvel. Yes. Commissioner Newman.
Yes.
And I'll vote yes as well. So the previous, the vote on the penalty for the leaving the top three donor off the mailings is reconsidered. And do we have a motion? I'll make the motion that we assess a penalty of $10,000. Is there a second?
Yes. Second.
It having been moved and seconded that we assess a penalty of $10,000. Is there any discussion? Let's have a vote. Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Marvel. Yes. Commissioner Newman.
Yes.
And I'll also vote yes. And I want to thank Mr. Tardy.
And Commissioner Leclerc.
and Commissioner Leclerc.
Well, thank you. We'll try to have a quicker reflex.
Another cup of coffee, maybe. All right, we'll move on to issue number 5 on our agenda. This is the issue regarding contribution reporting by Maine Families First PAC. Mr. Wayne, would you like to tell us about it?
Absolutely, but I did want to check with our assistant Julie. Was Sarah Sally on the Zoom earlier? Did she want to participate?
No, the Sally that I saw was actually Mr. Burkhan.
Oh.
That was.
Oh, that was Dr.
Okay, all right, okay.
That's just Sally was sent a written notification, but not a Zoom notification since she had been here prior. I wasn't expecting her to do so.
That's right. I just wanted to note for the commissioners that the complainant, Sarah Sally, expressed regrets that she could not be here today. It relates to a family matter that has come up, and she wanted to be here, but she couldn't make it.
Okay, great.
Yeah.
Great, terrific. Thank you. But we do have Mr. Vanderholst here. And Mr. Wayne is going to give us a little background.
So this relates to the Maine Families First PAC, which registered with us on September 9th. And it has filed a number of reports with our office since it registered, and all of the reports indicate that the PAC's only contributor reported to date is Mr. Thomas Klingenstein. On October 7th, the PAC had filed an independent expenditure report that stated 2 days prior, on October 5th, it had made an expenditure of $999,245 to a political consulting firm, FP1 Strategies, for television advertising to oppose Governor Mills. But what Ms. Sally noticed in the complaint that she filed was that as of September 30th, just 5 days earlier, there had been no contribution reported that would be sizable enough to cover a $999,000 expenditure on October 5th. So in her complaint, Ms. Sally is stating that this time frame suggests that the PAC received a pledge from an existing donor and relied on that pledge to create an advertisement, and then asked the donor not to send the money until October in order to avoid public disclosure of the contribution, and she asks the commission to investigate this. So we have turned to the PAC and through its counsel, Mr. Vanderholst, for responses, and we received 2 declarations that were submitted under penalty of perjury from Terry Schilling, the principal officer of the PAC. And what Mr. Schilling explains is that Mr. Klingenstein is the PAC's only donor. He did not make a pledge of money before October 1st. It's been reported that Mr. Klingenstein contributed $100,000 on October 3rd. And what Mr. Schilling says is that on October 5th, it placed the order for the ad with FP1 Strategies. And on October 5th, that's the date that they agreed to pay FP1 Strategies. And it did not commit to that television expenditure until after it had received the $1 million on October 3rd. So what the PAC is essentially saying is we didn't have a pledge for this $1 million. We received them $1 million on October 3rd. And then we placed the order for the ad and we agreed to pay the vendor for the ad. And that's the explanation from the PAC. Mr. Vanderholst can supplement and correct any information that I provided or correct anything I said. So we offer some staff analysis in the memo, which is, I think that our point of view is that Mr. Klingenstein, his role as the only contributor has been reported and publicly reported on in different stages of this. And we are unsure that there's a strong informational interest in trying to figure out if he had made a pledge earlier. And we also discuss how we are not that well set up to even receive reports of promised amounts that have not been received. So thank you.
Terrific, thank you. Do any commissioners have questions or comments for Mr. Wayne? Okay. Is there anybody attending today who'd like to speak about this issue? This is question 5 on the agenda. Okay, Mr. Vanderholst, would you like to address us?
Sure thing. Can everybody hear me okay?
Could you speak up just a tad?
Yeah, and I can, hopefully it's not on my end. Let me see. Turning up the volume on my end, is that better?
That is better.
Okay. I thought that that would only control my speakers, but I guess it controls what it hears as well. Yeah, Joseph Vanderhulst, speaking on behalf of the respondent Maine Families First. We don't really have much to add beyond what was in the commission memo, the follow-up memo here. With regard to a couple of clarifications in case the numbers are jumping out at people. The contribution on October 3rd was 1.5 million, and that was disclosed on the 11-day pre-election report. And then, yeah, the spending was committed on October 5th, making the report due on October 7th, which is when the independent expenditure report was filed, and which is at the same time or on the same day that public dissemination occurred. So our report was filed at the same time, and I don't know what the times were, but maybe even before the ads began to air. Yeah, with regard to the contribution, there was no pledge or promise before it was received on October 3rd, and there's no evidence that there was any pledge or promise. And then, well, I guess I already mentioned the timing of the independent expenditure report, the 2-day report getting filed. I guess the last thing I would say is, as Mr. Wayne points out, I don't think there could really be any more or any greater disclosure than what we did here, in terms of putting the donor on the ads, and then reporting everything on the reports as it came in. There couldn't really be any more transparency. This is pretty much all that we have, and we obviously agree with this staff's recommendations in their memo.
Thank you very much. Are there questions from commissioners for Mr. Vanderhulst? Questions or comments? Commissioner Leclerc.
Yeah, how does one transmit $999,000 from one entity, from Mr. Klingenstein to you guys?
Sorry, how does a PAC pay it, or how is it received?
How did Mr. Klingenstein, what was the methodology for the money coming from Mr. Klingenstein? Was it a wire? Did somebody walk a check? Was there a bag of money? I'm just trying to figure out what was
it was small unmarked bills. I'm sorry. It should be in the, do your reports, I'm looking at the report right now, I'm sorry. I know in some states, PACs are required to identify check number, whether it was a wire or whatever. I'm not seeing that here, but I can confirm, but I would imagine it was a wire.
And
both incoming and outgoing were wires.
So if
Yeah, I'm sorry, not to interrupt. I'm looking at the report again, and yes, there are wire transfer service charges. Outgoing, yeah, those are on the report. So yeah, the wire transfers, yeah.
Perhaps you could point it out for me, but so the wire transfer was initiated on what day, and when was it received the same day as it was initiated?
It was received on the 3rd.
And when was it initiated?
Well, that I don't know. I don't have a timestamp on that. I can try and get those timestamps.
Because that would be salient to what we're considering today. I mean, if it, I mean, the reason I'm asking this question is I just wire transferred some money. It took, I can't remember how long it took, but it took more time. I thought it was instant, but it's not. So I think it's, I would like to know if it was the same day or if it was not the same day. And if it wasn't the same day, would ask the question of whether you had noticed that there was a wire transfer being made. Do you see my point?
Yeah.
Mr. Vanderholst, is that something you could find out within the next, I don't know, hour or so?
Yes, I can try to do that.
So why don't we take a break from this item, and we'll give you a chance to find out the answer to Commissioner Leclerc's question. And
Okay.
We can consider something else in the meantime.
Okay.
Terrific. Thank you very much. That having been said, we'll move on to item number 6. This is the proposed legislation. Is there anybody in the audience who wishes to comment on the proposed legislation? I'm going to put that off until the end there. If there's nobody in the audience who wants to comment on that, we can put that off and we can deal with the things that people are here. Moving on to agenda item 7. This is a request for a waiver of a late filing penalty from We the People PAC. Mr. Wayne, would you like to tell us about it?
Sure. This relates to 2 independent expenditures made by the PAC. The reports, based on the dates of the expenditures, the reports were due on October 12th and October 19th. But the report wasn't actually filed until October 24th. So those 2 reports respectively were 12 days late and 5 days late. And the preliminary penalty for the first report is $5,000, and the preliminary penalty for the second report is $99.96. And the PAC is requesting a waiver of the penalties. And Mr. Aaron Preganow is here on, or he's here on behalf of the PAC, and possibly counsel may be provided as well. I'm not sure. In his request, based on his request, our understanding is that there were 2 errors made in the filing of the report, and I'll just offer a staff view on this, but if I've misstated anything, I'll rely on the PAC to correct me. Our understanding is that when Mr. Preganow entered these expenditures, he entered them as what we would call the wrong expenditure type. When a filer clicks on the new transaction button to file and to enter any kind of new data, there are options for contributions, expenditures, independent expenditures, loans, and debts. And it was designed this way. It was sort of redesigned this way to overall help PACs and party committees file independent expenditure reports. Well, I realize it might have backfired in this particular case for this particular PAC, but there was a reason behind. I think we switched to this method because we thought it would be an improvement. So that was one issue, is that if a PAC or party committee is making an independent expenditure, they have to use that transaction type. The other issue is that no report was filed. Our understanding is that the transactional information was entered into the system, but there's a process that is always the same for any kind of campaign finance report that is entered in our system, where the filer has to go to filing page. They have to click the red file button. And some of the screenshots in here illustrate this, that there's a certification. I mean, I can walk through it if you'd like, but there's a certification that the filer has to make in order to file a report, that the information in the report is accurate and complete. And then they affirm that, and then the report is filed. So from our point of view as staff, we absolutely appreciate that there were good intentions here. The data, we accept that the data was entered on time. The reason we are not recommending a full waiver in keeping with the usual practice of this commission when there are sort of routine or common errors like this is that we want to make sure that PACs and party committees and others finish the job. So the information is on the right report on time for interested people and for the public to see it. And that's why we don't typically recommend a full waiver, even when there are very good intentions by the PAC or the party committee. We agree that the $5,000 preliminary penalty is too high. That's disproportionate to the violation here. So we were recommending a reduction of that penalty down to $1,000. Then we would recommend leaving the $99.96 as is. So just to, the recommendation is based on past practice. We can vary from that, but the goal is to underscore that it's sort of the duty of the PAC or the party committee to see it through to the end. And part of that means filing it and confirming that you filed a report. We think that's a reasonable expectation.
Okay, terrific. Any questions from commissioners for Mr. Lane? Okay, is there anyone here? Yes, Commissioner. I want to drag you onto this board in the worst way, don't I?
Thank you, Mr. Chair. Joshua Carty, counsel for the PAC. And so no disagreements with the facts. Mr. Cardinal is here. He's a volunteer treasurer, and it's just this. I think this fact pattern just underscores the peril of participating sometimes and putting your name on his treasurer. It's tough to argue with the need for compliance, but this was a mistake that was immediately corrected, and after consultation with commission staff, and then the very nature of coming in, I think Aaron wishes that he'd come in to get the hard form affidavit a week earlier. But certainly respect, for example, Commissioner Newman's comments earlier about, consistency and establishing the baseline. I'd like to be able to argue that it should be less than the staff recommendation. But I do think staff recommendations need to be made, and they need to mean something. And so I frankly agree with it.
Thank you. Thank you. I appreciate it. Any questions or comments from commissioners from Mr. Carter? Okay. Is there anyone else who'd like to speak on the issue? Mr. Craig?
Just here to, if you have any questions to him.
Okay. Does anybody have any questions for treasurer?
If we impose a fine, is someone going to take it out of your pocket?
I don't think.
Sorry. Now, just a technical question for Mr. Bolton. The staff has found a violation already, so we're just dealing with the penalty.
Correct. Whether you want to make a commission determination under subsection 6 to reduce the penalty based on mitigating circumstances.
Okay, terrific. So I'll start our discussion off with just a comment that we have two issues here again. We've got the report that was 12 days late and the report that was 5 days late. And I think I'd like to handle those in two different motions. I'll make a motion regarding the report that was 12 days late that we reduce the fine to $1,000.
Second.
Is there a discussion on that? Okay, we'll take a roll call vote. Commissioner Leclerc.
Yes.
Commissioner Hastings.
Yes.
Commissioner Marvel.
Yes.
Commissioner Newman.
Yes.
I'll also vote yes. On the second report that was 5 days late, I will move that we assess a penalty of $99.99. Or I'm sorry, $99.96. I don't want to take 3 extra cents. Is there a second on that? Second. Thank you. Is there any discussion? Seeing none, I'll call for a roll call vote. Commissioner Leclerc.
Yes.
Commissioner Hastings.
Yes.
Commissioner Marvel. Yes. Commissioner Newman. Yeah. I'll also vote yes. Thank you very much, and thank you, Mr. Tardy, for helping us through that. We'll move on to issue number 8, which is a request for a waiver of late filing by Planned Parenthood Maine Action Fund. Mr. Wayne, would you like to tell us about that?
Sure. I think we're getting Marnie Maynard on the Zoom.
Okay, are we getting someone on the Zoom?
Well, shall I just start? And if Ms. Maynard has any issues, she'll let us know. This is a case of a late independent expenditure report by the Planned Parenthood Maine Action Fund PAC. For PACs and party committees that made independent expenditures in the spring or the summer of 2022 in order to influence the general election, there is sort of a catch-all deadline for them to file the independent expenditure report on September 9th. And this particular PAC on August 24th made an expenditure of $4,200 for campaign literature, and it was specifically the kind of literature that you hang on doors. And so that was an August 24th expenditure. It expressly advocated for Janet Mills or against Paul LePage, so that required an independent expenditure report, and it should have been filed on September 9th. Ms. Maynard is the authorized agent for the PAC. She's not the treasurer, but she's somebody that the PAC is authorized to file reports. And our understanding from her letter is that her role with Planned Parenthood is that she files reports, campaign finance reports with Maine and with New Hampshire and Vermont. And she explains that she tried diligently to find the different rules and requirements in the 3 different states, but she was not aware of this report that was due on September 9th. So the report ended up being filed on October 5th, which was 26 days late. And the preliminary penalty for the report is $2,433. Our staff did, Emma Burke, our new political committee and lobbyist registrar, newish, did file send around an email that we've included in the packet, which the 2-page file that was attached to an email. It's called the 2022 Fall Filing Guide for PACs, PQCs, and state party committees. I think that states pretty clearly that IEs made on or before September 9th must be filed no later than September 9th. So we think that advice is pretty clear, but Ms. Maynard explains in her letter that she didn't receive the, or she didn't see the email, I believe. So the staff, our point of view on staff is that the preliminary penalty of $2,433 is just disproportionately high. We understand she was inexperienced and sincerely trying to learn these procedures. That's Emma's impression from dealing with Ms. Maynard. So we would recommend a reduction down to $750, which is something of a minimum. It's not an absolute minimum. The commission can still go lower, but it's sort of an informal minimum of what the staff has been recommending since 2018 for routine errors by PACs.
Terrific, thank you. Are there questions or comments from commissioners? Okay. Ms. Maynard, would you like to speak?
Good morning. There's nothing I can add. I think everything was covered.
Okay, terrific. Thank you. Let me see if commissioners have any questions for you. Do any commissioners have any questions or comments for Ms. Maynard? Okay. So is there anybody else here who'd like to address the question? All right, so I'll proceed to our discussion portion. I would start it off by making a motion that we reduce the penalty of $2,433.60 to $750. Is there a second? Second. Okay, now it's time for discussion amongst commissioners. Does anybody wish to discuss the motion?
Well, I'll just note these are just some thoughts. I don't really have an answer to my thoughts out loud, but just comparing the item we just addressed to this item, if you look at a percentage of the expenditure, I think the ultimate assessment of the $1,000 with respect to the financial activity on the previous item amounted to a penalty of about 3% of the total expenditure. I'm saying this because I'm using my calculator, but I may have my math skills are rusty. And this $750 fine here would result in a penalty of about 16% of the related financial activity. So I'm not saying that that's right or wrong. I'm just, I just did that math and I noticed that discrepancy. However, I appreciate the commission staff's point of sort of having a, not necessarily a mandatory minimum, but maybe a suggested minimum. Because again, obviously these, as we discussed in all of our hearings here, how important, prompt filing of these independent expenditure reports are. So that's my comment.
And I think I would point out that there are mitigating and exasperating factors that occur in both of those cases. For example, the previous one, it was 12 days late. This one, it was 26 days late. So I think, in my opinion, I think the reduction to 750 is a just result. Any other comments, questions from commissioners?
I would just want to express what I know we're all thinking, that we empathize with someone relatively new to this system, trying to do it for 3 different states. We get that. This is not to be taken personally, but we need to be consistent in our practices as much as we can. And I will tell Commissioner Newman that I was doing scratch work by hand.
Wow.
So you have me thinking of similar thoughts.
Technology.
Terrific. Any other questions or comments from commissioners? Okay, we'll move on to a vote then. Commissioner Leclerc?
Yes.
Commissioner Eason?
Yes.
Commissioner Marvel? Yes. Commissioner Newman?
Yes.
And I'll also vote yes. And thank you, Ms. Maynard, for coming and helping us.
Thank you all. Have a good day.
Okay, moving on to agenda item 9, the request for a waiver of late filing by Danielle Feinberg.
Right. Our understanding is Ms. Feinberg,
She's going to join us. Terrific. So.
If you will hear us, she just wants to start the video a little later. I'm not sure if that's.
Ms. Feinberg, can you hear us?
Does everybody see that note?
I can't see what it says, though.
It says that she can hear us, but we wanted to know if we could hear her, and we cannot.
We cannot hear you.
I'll respond there if anybody else wants to.
Ms. Feinberg, can you hear us? And can you speak so that we can tell if we can hear you? We can't hear you. Are you on mute? No? Okay. Maybe our crack technical team can
Can you hear me
fix
now?
that. Oh, very, very faintly.
That's. I can't do anything about that. I don't know how to do that.
Nope, now it's perfect.
Oh, okay.
Terrific, thank you. So we're going to address your item, and I'm going to start by having Mr. Wayne tell us a little bit about it.
sure, I'll relate my understanding of the facts, and Ms. Feinberg will supplement with anything additional. She was a candidate for State Senate District 2, and like all the legislative candidates, she was required to file a regularly scheduled report 11 days before the election, which was Friday, October 28th. And we received the report 1 day late. It's our understanding is that the report was filed late because there was one person who was not the treasurer, not the person I believe who was filing the reports for her, but was someone who was overseeing social media purchases. And he was the person that understood the specifics of purchases made through Facebook. So on the day the report was due, this gentleman, who I think was a volunteer, was unavailable to give the candidate or the treasurer the specific information about the Facebook purchases. And I think the candidate explains in her letter, she could see the overall total for the Facebook, but she couldn't get the specific dollar amounts for the purchases. So that resulted, our understanding is, in the report being filed one day late. And the preliminary penalty for that is $368.12. And from the staff's point of view, we don't doubt that that was a contributing factor or the cause of why it was late. But the report was required. And from our point of view, she could have filed a substantially complete report. She could have reported all the other expenditures. She could have reported a total for all the Facebook expenditures as a single expenditure, and then she could later have amended the report. So from our point of view, that may have been the cause, but it doesn't amount to a complete excuse for the report being late. Because the amount of the preliminary penalty is $368.12. That is within the $300 to $400 range of what we've been recommending for good faith mistakes by candidates. So we were not inclined to recommend any kind of a waiver. But as I said earlier, that's not a hard and fast rule. That's sort of what we go by. So we were recommending no waiver.
Sure. Any commissioners have questions or comments for Mr. Wayne?
Just for Mr. Wayne, and to prove I did my homework. I believe it's the next item has similar range of fines and whatnot, and that one, Mr. Hanrahan, is a recommendation to reduce it from 376 to 300. And this is 368, not recommending to 300. So is there something I'm missing?
There were minor differences, but we think that in the case of Mr. Hanrahan, that was based on a misreading of the advice. Our overall guidance, we don't think it was a good. We think we wish more attention. I think Mr. Hanrahan is here, so I don't mean to sound critical. We wish more attention paid to our guidance, but we understand how that could have happened, and there was an intent to file. In this case, we just don't have it seems like there's a slightly higher degree of fault from our point of view.
Okay.
Because there was no obstacle. Well, most of the report could have been filed on time, and that is what I think should be expected in this case.
Okay.
Yeah.
Thank you.
Can I just,
Oh, yeah, please.
just to clarify the process for me, if most of the report had been filed on time, let's say the Facebook advertisements was left, would then the penalty be assessed, would have been assessed just against that portion?
Thanks for the great question. That's not allowed under the law. The only sort of, we don't do like penalties for missing transaction. There's nothing in the law that suggests we should do that. So as long as the overall report substantially conforms to the disclosure requirements, it's not considered late, there's no penalty. And we tell candidates and PACs that they can amend the report at a later time as long as we're substantially complete. And there's really no enforcement result from that.
So I just want to make sure I understand. So if it had been filed without, it could have been filed without the Facebook advertising costs, there wouldn't have been, and then amended later, and there wouldn't have been any penalty assessed.
Right, that would have been an option. Or they could have just provided a total, an approximate, a total for all the Facebook expenditures. That would have been better, but of
And
course
then
that
amended that.
transaction amount wouldn't have been exactly correct,
Right.
but it would be an approximation of the different expenditures.
Any other questions, comments for Mr. Wayne? Ms. Feinberg, would you like to address us?
Yeah, we did our level best to get the report in on time. We had it sitting in the system, from what I understand from my treasurer, we had it sitting in the system waiting for the campaign staffer to be able to send those reports in. And had we known that filing an incomplete report would have been better, we would have done that. And as soon as it became apparent that my staffer could not physically get the reports to us because he was so ill. We did notify the commission. I did send an email telling them that we had a sick staff member. I wish I would have known just to file the incomplete. This is inexperience on mine and my treasurer's part.
Terrific. Thank you very much. Any commissioners have questions or comments for Ms. Feinberg? Okay. I'll start our discussion off by making a motion. I move that we do reduce the penalty, or that we do not reduce the penalty, and that we assess a penalty of $368.12. Is there a second? Okay, that motion fails for lack of second. Is there another motion?
I make a motion, we assess a penalty of $300.
Is there a second for that motion?
I'll second that.
Okay, so it's been moved and seconded that we assess a penalty of $300. Is there any discussion?
You know, I will say with respect to sort of trying to compare apples and oranges and trying to be consistent, which is so hard, and I feel like a broken record here, but you know, hearing what Ms. Feinberg said, it's hard to know what's better as your degree of fault, right? She was trying to be accurate, and so therefore weighted. And is that better or worse than finding an accurate one? I'm not sure. I'm not sure it's worse. So I am in favor of reducing it.
And it's certainly no comment on Ms. Feinberg personally. I'm right. It's a comment on the penalty is a comment on the process and the degree to which the process was followed. Okay, so any other comments, questions from commissioners? Okay, so it's been moved and seconded that a penalty of $300 is assessed. Commissioner Leclerc.
Yes.
Commissioner Hastings.
Yes.
Commissioner Marvel.
Yes.
Commissioner Newman.
Yes.
I'll also vote yes. Thank you, Ms. Feinberg, for coming and helping us out.
Thank you. Let me get this little one onto the bus. All right, thank you.
Mama.
All right, we'll move on to agenda item 10. This is a request for waiver of late filing by Stephen Hanrahan. And Mr. Hanrahan, are you here? Terrific. I'll ask Mr. Wayne to give us a little background first.
Well, I'll try to be brief. Mr. Hanrahan is a first-time candidate running for the House. There is what we refer to as a 24-hour reporting period. And that is the 13 days before the general election. And the idea of the 24-hour report is that if a candidate receives a contribution of $1,000 or more, or makes an expenditure of $1,000 or more, that's substantial enough that it ought to be filed in a special report within 24 hours. And that's why the report is called the 24-hour report. That's explained in our guidebook. It's explained on our filing schedule. And then the staff sent out, and there are a couple of communications in the materials that are relevant to this. That Lori Brand sent out an email on October 25th explaining in detail what is the 24-hour, it's guidance on 24-hour reporting period, and it explains that during the 24-hour reporting period, any transactions in the following list must be reported within 24 hours on the Commission's e-filing website. So we do our level best to tell candidates what they need to know about this requirement. And I don't want to speak for Mr. Hanrahan, but my understanding is between the references to 24-hour reporting period and that guidance, and then another postcard that we sent out, which really more related to the 11-day pre-general report, the report that's due for all candidates. His understanding was not that it had to be reported within 24 hours, but it had to be reported sometime in that 13-day period. I think that was the explanation for why the report was late. So on October 28th, he had placed an order with the Bangor Letter Shop, and the amount was $2,353. And so from our point of view, a report was required the next day on October 29th. And I just want to credit him with understanding that a debt is something that has to be reported in 24 hours, which is not something that every candidate understands. The preliminary penalty is $376.48, and we were recommending reduction to
Terrific, thank you. Any commissioners have questions or comments for Mr. Wayne? Okay, Mr. Hanrahan, would you like to address us?
Yes, thank you. I feel honored to listen to some of the monies before me. Not the $1 million club.
Thank you for coming though, and please introduce yourself and
I'm Steve Hanrahan, ran for District 16. My wife and I are the only two people doing this. I have no experience, and I looked at the criteria when you adjust. One is that the experience of the candidate, the scope of the campaign, and what harm. I don't think I harmed anybody by making a late report. And I do admit we did do that. We were confused a little bit by the wording, and just being the two of us doing it and running around trying to knock on doors, it was a little difficult. So I admit we did that. One of the things I noticed in the letter that I received is that you dropped the Planned Parenthood 70% of their initial fund. I got dropped 30%. Half of my campaign was financed by our retirement fund. So what I'd like to know is if we could do something different. If we could do the 30% that you did on the other campaign. I get $52 left in my campaign fund, which is money that came out of our retirement fund. So that's pretty much my thing when I came down. I always believed, I know this is a great technology, but unless you could sit and look at somebody in the eye. I remember the old days when you looked somebody in the eye and shook a hand and you had a deal. So I'm here to present myself that way. If you have any questions, it's just really kind of simple. I do admit that we did something wrong according to the rules, not intentionally, but it's just two people trying to make it through, you know.
And we appreciate you coming here to talk to us today. We really do. It helps us so much in our deliberations. Does anybody have a question? Yes, Commissioner.
A comment and a question, and the question is going to be a nasty one.
Okay.
The comment.
If you can do any worse than 12 weeks of Paris Island, have that.
This will be a cakewalk. I just want to comment that your sincerity and groundedness come through very strong. Get it. My question is this. We've spent some different portions of this morning, as you may know, talking about consistency and how do we get there and what's fair for everybody and things like that. Cases are not identical. The reason for expenditures differs, the size of the expenditures differ, on and on. We just found that a candidate facing a similar level fine got a reduction very comparable to $300. And I think you were in the room for that.
Yep.
So I'm wondering, how would you advise us in the context of trying to be fair and consistent? Why should we hold to that and honor your request and be consistent at the same time?
I spent a amount of time in sales and other things in my career. And an organization should be set up that if somebody is out of place, there should be something of redundancy. Oftentimes in business, when I was in publishing, oh, well, you know, Christmas is coming. Or, you know, excuses that are like, why didn't you plan for this? If somebody in an organization got run over by a bus, would the organization just stop? My excuse is inexperience and overwork. Okay, we did make the thing and we were confused and we had no guidance. But if you have a larger organization, where's the redundancy? Where are the people to pick up the slack? If there is somebody, if you know somebody's ill, what were their duties? That's kind of my answer to it. It's when we're in the Marines, somebody gets killed, another guy steps up. It's always one step after the other. And my wife and I looked at this thing, and if we could, I don't want to go into a whole review of how it's written. Sometimes things are written in a way by people that know exactly what's going on and are not easily interpreted by somebody that's not involved with the process. Mm-hmm. Most of the literature we got said, yeah, 24 hour, you know, I'm thinking 24-hour reporting period, but everything I saw, except one line, said between these dates, there's one line in one of the papers that says 24 hours since you talked to somebody about doing something. And I missed that. So I mentally made a mistake. But my mistake was something that was caused by two people that are actively involved. Not saying, I don't try to dismiss anybody's circumstances. But like I said, it was just the two of us. We made the mistake. I'll own up to that. If you're looking at a larger organization and somebody falls down on the job and nobody's paying attention, where's the leadership? So I understand where there would be a more severe penalty for something like that. In the service, they have captain's master, they have court marshals. And captain's master for the smaller offense and a more reasonable avenue of approach. So this would be kind of the same thing for me. What you just asked me.
Thank you. Thank you. Any other questions or comments from commissioners? Okay, thank you very much for coming, and we really appreciate it.
Thank you very much for allowing me the time to defend myself.
Of course. All right, is there anyone else who'd like to address the this question? Okay, I'll start off our discussion with a motion, and I'll move that we reduce Mr. Hanrahan's penalty to $300.
Second.
Is there any other discussion on the part of commissioners?
I would just add to the general conversation, not that it will necessarily help you in any direct way, that the biggest single pattern I've seen of people who incurred debt through fines or whatever through this process that I wish we could change is people understandably not having a full appreciation of the work required, the level of detail to listen to, the compliance issues of reporting and all those things. And in almost every case, if the people who came before us had just a slightly larger team or had someone to make a call to the commission to say, this is the way I'm reading this, does that make sense? Time after time, both parties would be not stuck in the position they're in. So I'm going to vote to support the motion, not with any great satisfaction, but to just say you have a lot of company, and I'm kind of sorry that you do, but it's what it is. It's a big task to take on running for office.
It is a tremendous learning experience. If you want to find about your community, who your friends really are, and who is willing to support you, I'm going to tell you, it's a shock.
Yep. And I want to say also that, having run for office several times myself, it's difficult. It's really hard. And I can't imagine doing it without help from friends and members of the community. So if you do it again, I'd advise you to try to find a core of people who can be there to assist you and help you out.
I'm 69 years old. I'm going to be the stick that pokes people from behind.
Well, that's a very important role as well. So thank you for coming today. Any other comments or questions from commission members? Okay, there's a motion that the fine is reduced to $300. Commissioner Leclerc?
Yes.
Commissioner Hastings?
Yes.
Commissioner Marvel? Yes. Commissioner Newman?
Yes.
And I'll vote yes as well. And thank you again for coming, Mr. Hanman.
Can I tell you the worst part of this?
Sure.
My wife gets the quote.
Happy to be of service. Okay, we'll move on to agenda item 11, which is a request for a waiver of late filing by David Thurston. Is Mr. Thurston?
Commissioner, could I just make a comment about procedure while we're waiting for
Please,
Ms. Hughes to join us?
please.
I just wanted to say that, we've developed these procedures over time. I explained how we increased the penalties in 2018. So we've settled on these ranges, $300 to $400 for candidates, at least $750 for PACs. I feel our role as staff is to be responsive to what you want to do. So I've heard a couple comments about, what's the percentage of reduction? And so that kind of has been lost in, or not given much weight in our recommendations in an effort to be consistent. But, viewpoints change, personnel on the commission change. So if you want to move towards a different direction and ask us to consider different things, we're very open to that. We don't, nothing is written in stone. This is just sort of what's developed over time. And it's our job to listen to what you want. So I just don't want you to feel like there's any resistance from us. We're sort of, this is the recent practice, so we're going to keep doing it. But if you want to ask for a different direction, we're really very open to doing that.
I don't feel any resistance at all, honestly. I think, there's always a zillion different ways to look at us. For example, look at a fine. You can look at it as a percentage reduction. You can look at it as a portion of the expenditure, or a portion of the misreporting, or how long the reporting was late. So you can parse it out in any one of a zillion different ways. And I think you guys, consider the big picture, and you make a recommendation based on the facts of the case at hand and based on the history. And I think that's very helpful for us. But I also don't feel bound by that in any way. The only reason I've been making motions to impose the fines that you recommended is that I think they're reasonable and I think they're just. So, agreed. Someone's on the screen. Is this someone to speak on the matter regarding Mr. Thurston?
No, I just came on because they prompted me to come on. I'm the
All right. Which matter are you here for, ma'am?
I'm on number 11.
Oh, okay, 11.
Yes.
Yeah, that's right.
That's the one about Mr. Thurston. Terrific.
Yes.
So what I'm going to do is I'm going to have Mr. Wayne tell us a little bit about the issue, and then we'll give you a chance to address this.
Thank you.
Thank you. So we're going to be receiving comments from Ms. Lee Hughes, who's the treasurer for Mr. Thurston's campaign. He was a first-time candidate for the House of Representatives, and the campaign was required to file a report 11 days before the election, and it was filed 1 day late. And the preliminary penalty for the 1 day late filing is $139.81. And Ms. Hughes is here to speak in favor of a waiver, which she had requested by letter. My understanding is that there are a couple factors here that led to the late filing, and I hope Ms. Hughes will expand on this if I'm leaving anything out. She had, I think they call it a miscommunication with one of our staff members, Lori Brand, where Ms. Hughes asked for some assistance, and Lori Brand thought that well, she's available if you would like to hear from her later on. She's within the office, but not in the room at the moment. I believe that Ms. Brand took what she was being asked to do was to confirm that the data had been entered correctly. She didn't understand that Ms. Hughes had any interest in her filing the report or confirming that the report was filed, but Ms. Hughes had that expectation. So Ms. Hughes, I think, was under the impression that the report had been filed, even though she didn't personally file the report. The other issue is that Ms. Hughes has memory difficulties relating to an injury from 3 years ago. So with all these cases, the commission staff has sympathy for folks like Ms. Hughes or Mr. Hanrahan, and Mr. Thurston is a first-time candidate. But our point of view is that the penalty is $139.81, and that there are confirmations available to a treasurer or a candidate, and Mr. Thurston might have some role in this too, even though he wasn't filing the reports, to confirm that the report was filed. There is a message on the screen that is up there for 5 seconds. There is an email that is sent immediately, and there are various lists of reports on the website. So our consistent message is that it's up to the candidate or the treasurer or the authorized agent who's ever filing the report to take advantage of those emails and screen messages and make sure that the report has been filed. So we would recommend no reduction of the 139 penalty because even though this was a matter of good faith, we want to underscore the importance of actually seeing it through the end, confirming that the report has been filed, so the information is available to the public and to the opposing candidates. So that's our recommendation.
True. Thank you, Mr. Wayne. Any comments or questions from members of the commission?
Quick point of it.
Please.
Mr. Wayne, is that understanding that until the last button is pushed to put the filing, the public cannot see the information on the tentative report?
That's correct.
Excellent. I mean, that's why actually getting it filed is critical. Thank you. Ms. Hughes, would you like to address us?
Yes, and I listen to all of this and I understand and totally respect the need to have fines because, you know, you have to have people do things in an orderly way. And so I've worked for 2 other candidates prior to this. So I had, you know, 2 years in between but before this last one, I had a traumatic brain injury and I very much enjoy politics and I want to be doing all this and I'm functional. I'm a librarian, so I work, but I'm insecure now I'm very conscientious and I'm very insecure about, I just want to make sure I do it all right. So I contacted Lori, who I've started to develop a nice working relationship with her and I felt like I could be honest with her. And so I did my whole report. I thought I had clicked enough to submit. But I sent her an email and I said, I think I've done everything right, but could you please just give it your eye? I know you're really busy at the day before the deadline, but so I looked back at my email and I could see how she might have misinterpreted because I didn't specifically say, did I submit this correctly? But that's what I meant. And maybe I can't remember the exact words, but I guess she took it like, yeah, that looks fine. So she just wrote me back, yes, you're all set, great, or something like that. And I was so happy. So a day before I got it in early, I closed my computer, I go on my merry way. I just thought it was fine. So I didn't look the next day. And I don't check my computer regularly because I don't really get that many emails. And so the day after that, I did look on for something and there was the penalty letter. So I called her up and I was like, but Lori, that's why I checked with you. I wanted to do it right. And, I was at first upset with her because it was like, wait, you told me it was okay. And then I realized, okay, I can see that was a miscommunication and she did her best and she's been wonderful. So I don't fault her in any way. I just, it's just kind of like a little tragedy because I try so dang hard. And in the end, even with help, I couldn't do it. So, I don't know what to say. I told her yesterday, I was like, I think that was my last candidate. There are actually people here trying to see if I'll run. And I'm just thinking, well, geez, I can't do the treasurer job right. I think I'm going to hang it up, but I think I'll have 2 more years to calm down and I guess, and maybe try again. I really still want to be involved in politics, but it just seems like there is a little flaw, and maybe it's a big flaw because there seem to be a lot of people that are in my boat that this computer, maybe the whole site should be looked at again, because I swear it says submit. You push submit, you think you're done. And I know from my past, everything has gone smooth as silk before this injury. With my other 2 candidates, I didn't have any problems. And I haven't had any other problems with Fuzzy's or David's campaign so far, but that was, it was just what I said. So I think, wow, you work so hard, you do this all for free, it's a lot of responsibility. And then you get hammered with a fine for a thing that you really thought you did right, you know? And I know that's not a criticism of you guys, because like I said at the beginning, you have to have these fines and you have to have these procedures. And I don't expect mercy here, but I think it's worth your time also to not probably have to go through this all the time with candidates in the same boat, in a similar boat than mine. So I just thank you for letting me spout on and on. I'm sorry.
Don't be sorry. Thank you for coming and thank you for providing some input.
Yeah.
I can say from my perspective, I can completely understand the miscommunication that happened here. You kind of asked a vague question and got an answer to that question, but it wasn't the question that you thought you were asking. So
yeah,
I can completely see that. And I can tell you as you know, a former member of the legislature, that it's a tremendous form of public service. And I think if you're considering running, I think you should do it.
Thanks.
It's a great way to provide service to the public. And I would encourage you to do that. So any questions from commissioners, questions or comments from commissioners for Ms. Hughes? Yes, Ms. Claire.
It's probably in here somewhere, but just briefly, what was the thing that needed to be done after the submit button that you didn't do?
I don't know. I think there's a second. I mean, this is my stupid memory. How many times have I done these reports? But I think there's a two-step process to it. And I'm gonna go through this again with Lori this time. And I guess just make sure I'm gonna ask, she understands with me this time. What's the second thing that I didn't do that flubbed it up? Because
maybe I can ask Mr. Wayne to describe what needs to happen.
Sure, and we did include some screenshots in your materials. If you actually want to see what it looks like on the screen, it's the 4th page from the back. 4th paper page. For those of you that have paper packets. It's the head. If you're on the right page, you'll see the heading at the top that says final 2 steps in filing campaign finance.
Oh, it says 2 steps.
So you're directed to go to this top screen. That's the sort of the filing page that provides us financial summary of what's in the report. And it's not colored on your paper version, but in the upper right hand corner, there's a red button that says file report.
Yes.
So that's the next to the last step. You click
Maybe
that.
that's the one I did.
Okay. And then the very final step is, because this certification is required by law, is that there's a statement which is an affirmation that the report is accurate and complete.
I did that.
And there is a submit button on that little pop-up screen. So I don't know. So those are the final 2 reports. Click the file button and then submit to make the affirmation. And then as explained on the following pages, there are the different confirmations that are available. There's the black, I don't want to belabor it, but there's the black message that's up there for 5 seconds, which actually is a long time on when you're interacting with the user interface. It's there for a while. And then there's an automatic email, and then there's other. So yeah.
Do you see that, Commissioner Claire? Do you see that in the packet?
Yeah, so Mr. Wayne, the last thing that needs is that it's got an exclamation point, the white square. You press that submit, and is that the last thing that needs to be done?
To file the report. And then we would recommend people actually look for the confirmation that the report is actually been filed.
But if they did that correctly and they didn't look for the confirmation, that would be the last thing.
That would be the last step.
I just wanted to clarify that.
Thanks.
Any other questions or comments? Yes.
With respect to the printed materials we have, it's on the top of the page. It says final 2 steps in filing any campaign finance report. That's for our benefit. It doesn't say that on the website, right? It doesn't say there's 2 steps. It just says you just see this first screen and then you see the second screen.
Correct. I formatted this for your benefit. Yeah.
I just wanted to add one thing, that my first contact with the commission was sitting in her chair. I think it was in 2016, and everybody does make mistakes, and I hope that you'll continue as I did. I became an unsuccessful candidate in 2011. So anyway, it's not personal. And
I know. I figured, and Laura even warned me, it's probably not going to change anything, but I felt like I was curious to see your process, and I really wanted you to get the feedback, because even when I had my whole brain working, I remember it isn't easy. It seems tricky. It just seems like, and I remember having, oh my gosh, I don't think I did this right. So I don't know. It's also hard as we get older to try to find instructions online and everything. I used to have one of those folders, I think you guys have, because I went to Augusta and got it. But it's outdated. So I mean, that's another good feedback thing I could give when people sign up to be treasurer. Mail them a thing in paper or, get them the instructions.
Well, we definitely appreciate you coming in and speaking with us.
Thank you.
Any other questions or comments? Okay. I'll start off our discussion by moving that we assess a penalty of $139.82. Second. Is there any discussion of the motion?
Yeah.
Yeah, please.
This one is difficult for me because this was an honest mistake, but Ms. Hugh did what we asked, which is to call the commission if you're concerned. And this is not at all, there's clearly a miscommunication, so this isn't at all a criticism of staff, but I'm inclined to actually to potentially make an amendment to the motion to reduce it to $100, because I do think that Ms. Hugh has limitations on the disability that she recognizes might mean that she didn't do this properly. She contacted the commission in order to do it properly, to do it early. We also talk about that. She did it a day early. And so for those are the things I'm thinking. And while I have the floor, I also wonder, Mr. Wayne, about, I've heard this a few times now with this confusion with the 2 steps. And of course, if you don't know that something's about to come, you don't know to wait for it. And I wonder if there's something on the website, or if it's relatively easily to amend with this first screen that says, file report, this is the first of 2 steps to finalize your submission, or
There were 2 moves coming at you.
yeah, like,
something.
because file report, I could see how you click that and computer spins for a minute and you think it's done, and I don't. To try to help candidates. So those are my two comments.
Would you like to make a motion to amend?
Sure, I would like to make a motion to amend that we reduce the fine to $100, because I do think it's confusing, but mainly because I think Ms. Hugh did what we as commissioners want candidates to do, which is to contact the commission.
Is there a second?
I'll second that.
Okay, it's been moved and seconded that the motion be amended to make the amount of the fine $100. Is there discussion? Okay, we'll have a vote on the amendment. The amendment is to modify the motion to assess a penalty of $100. Commissioner Leclerc?
Yes.
Commissioner Hastings?
Yes.
Commissioner Marble? Yes. Commissioner Newman?
Yes.
I'll also vote yes. So now we move on to the primary motion that's been amended to assess a penalty of $100. Is there discussion about that? Okay, we'll move on to a vote. Commissioner Leclerc?
Yes.
Commissioner Hastings?
Yes.
Commissioner Marble? Yes. Commissioner Newman?
Yes.
And I'll also vote yes. So thank you, Ms. Hughes, for coming, and thank you for sharing your thoughts with us. Yes.
Thank you, especially to the women. I feel it, girls. All right. Sorry, guys. Have a great outing.
We might as well just leave now.
Anyway, thanks so much. Okay, one more
Commissioner
item. I'm off.
I just want to ask Jonathan a question about the confusion. I guess comes on this one, that even though the file, the report had not been fully filed and the public couldn't see it, the commission staff could see it. So that's where you can see it, and I can see where that came about, although I have to say, she probably had filed several other reports that had the same two-step process, so.
Yeah, but her memory.
But nevertheless, I can see what I see. Staff can see a partially completed report.
So can they.
Yeah, so can they. So it's just I lose track of that.
That's correct.
All right, let's move on to number 12. This is the request for a waiver of late filing by Scott Guyson. Guyson?
Yes.
Excellent. I hit it right on the nose. You're welcome to sit there. I'm going to ask Mr. Wayne for a summary of what's going on here first, and then I'll turn to you for some thoughts. Mr. Wayne.
Sure. Mr. Guyson is a candidate for the House of Representatives, and I think this is either his 4th or 5th time running for office. And like all the legislative candidates, he was required to file a campaign finance report 42 days before the election on September 28th. And that covered financial activity through September 20th. In a conversation with the commission staff, a little more than a week later, he disclosed, he disclosed that he had entered into some sort of obligation to pay Frame Media, which is a political consulting firm, $6,771. I don't think he knew the exact amount, but there was some sort of agreement or order or something in place that our staff viewed as a promise or an agreement to make a purchase from Frame Media. Frame Media is a company based in Portland that I know that the House Democratic Caucus encourages a lot of their candidates to use this. And what they frequently do is the candidates who use the service pay a large fee for a number of different types of services, mailings, other kinds of communications. So from our point of view, the report that was filed on September 28th really should have included an unpaid debt in the amount of $6,771. And Mr. Guyson explains that based on his business experience, his habit is to report expenditures when the payment is made. And that is understandable. A lot of candidates understand that, but the law, our advice and what we think the law requires is that if you make an unpaid debt or an obligation, that has to be reported. The reason that this matters is that there can be a lot of weeks go by between when the candidate actually orders the material and they actually pay for it, especially with an organization like Frame Media. I can't comment knowledgeably about their business practices, but I think they will actually allow payment to be received sometime after the services are delivered. So if our state's campaign finance reporting system was centered on when payments are made, it might be that considerable services would be purchased and may be delivered, but not actually be paid until relatively late in the election cycle, maybe after the election even. There would be no pre-election reporting of when the debt was paid. I don't want to say that that's what happened in this circumstance, but that's why we believe it matters. So given the large amount of the debt, which is $6,771, we think that would have been meaningful information to have in the report that was filed on September 28th. And so therefore we were viewing this report as not substantially complete. That's the reason we view it as late, is that it didn't include this debt. As part of this educational process, we viewed it late. We notified Mr. Guyson that the preliminary penalty amount is $135.43. Given the information I shared earlier about the track record and making sure reports are on time and complete, we would recommend no reduction.
Let me ask, and I just want to verify for my own purposes that this report reported no expenditures, right?
Is that correct? Well, there was one, Lori Fran saying there was one actual expense.
How much was the expenditure?
It would have been his MCA.
Oh.
Oh, right, but that's,
That's the other way.
That was.
yeah, that's
receipt of money.
that's in.
Yeah.
Right.
Yeah. Okay, and then, so later on, the report was amended to include the $6,771 obligation. Okay, thank you. Any other questions for Mr. Wayne from commissioners?
I
Yes,
have a-
Commissioner Leclerc.
just have a background question. So we have in front of us, I don't know how many, 5, 6, 7 of these reporting issues. And this is it for this period?
I think there will be a few more that you'll hear in December.
Okay. Out of how many campaign finance reports, if you could ballpark it, were filed during the period that this?
I would say, I mean, if you include the regular reports that are filed by candidates and PACs, and you were to include independent expenditure reports and 24-hour reports, I mean, it would be in excess of 800 reports.
Easily. I mean,
Maybe, yeah,
you figure probably nearly 400 candidates.
500, more than 500 candidates.
Yeah,
With 125 PACs.
4 or 5 reports from each.
Well, yeah, I mean, there was the one that was due 11 days before the election. Yeah, well,
There's a 42-day report and there's.
well, if you include the September report, then it would be well over 1,000.
Yeah.
I was just trying to gain some perspective on that. This, I think, is actually a very small percentage of errors that, or whatever, for whatever reason, errors made compared to the large number of reports during this period. If my
I think that's correct.
Thank you.
Any other questions or comments for Mr. Wayne? Mr. Geisa,
Yes.
go ahead.
Okay. As noted, I have done this before, although I hadn't planned on going this time. I was asked to, so this steps up when one has to, I guess. I've gone back to my business experience because it was noted by Mr. Wayne that when I was in business as a remodeling contractor in largely the Boston area, licensed contractor there, I've worked with a run right system. So, you know, among other things, I would write my checks that would be entered into my books at that point in time. That was my understanding about how to do bookkeeping. I didn't want to become a bookkeeper and learn all the various and sundry things. I wasn't interested particularly, but that worked. It was a system that worked for me. It was efficient, clear cut. That's my understanding of a bill and paid and due and payable. This year, it was a confluence of difficult processes all coming together in one fell swoop. One is that my energy to run a campaign in a serious form is diminishing this time, especially since I was asked to run rather than jumping in the water on my own. But more importantly, this year, my process with Frame Media was difficult because I couldn't seem to get them to give me data that I could use. And I understand that I could change it later, but I didn't understand that not having anything reasonable as a database from them made it difficult for me to, what's the bill? How much? What am I getting? And every time I called or tried to reach out to them, I tended to get a new person answering the question that would then start a process differently. So I couldn't seem to get an answer to what the bill was. So when I, said to Lori that I had no expenditures, that was my understanding. Because I didn't even have a number that I could plug in at that point in time. Everything was somewhat arbitrary because they had already given me 3 or 4 varied numbers depending on things, but that wasn't what we were going to do anyway in conversations that I had with them. So I quite honestly didn't think that I had a bill because I hadn't cut them a check yet. And I was hoping to be able to do that. And in the past, I have done that much more expeditiously. So it's never been something that showed up
in my experience with the clean elections, with the commission and the clean elections process. So I didn't have any basis for thinking that I had done anything wrong. I didn't consider it a mistake. I don't even at this moment in time consider it a mistake. I consider it a system issue that could perhaps be addressed in it. Because people need to understand that when, as Jonathan pointed out, when you incur debt, that's how the commission judges the debt to be due. Even though I didn't have any sort of a number that I incurred. So that's my biggest argument to that. Delivered, I didn't deliver the check to them until I ordered it, basically. It wasn't something that I had before that. So again, when I talked to Lori and she said that she disabused me of that thought process and told me that, in fact, that when I ordered it, that was the first time that I had ever seen that. I think Lori would communicate that I was surprised by that. It didn't make sense to me then, as it doesn't actually even now, although I understand that's how the process is. But I suspect that there's a lot of people out there running the office in the same situation that might not understand that. And that should be stressed somehow a little differently. Because, like I said, I didn't think that was something that I had done wrong.
Okay, thank you. Appreciate your input. I would like to say, from the commission's point of view, from my point of view anyway, that the whole reason for this statutory scheme, and as Mr. Wayne pointed out, is to inform the public about what kind of expenditures are being made by candidates. And it's particularly important when you're using public money to make those to make those expenditures, to keep the public aware of what those expenditures are. And that's why the statutes are written the way they are, to require reporting of obligations that you've incurred. As Mr. Wayne stated, if you were waiting until you had to pay the bill, sometimes you wouldn't even notify the public until after the election. So the way the statutes are written and the way the provisions are enforced is an important part of keeping the public aware of what's happening with their money in campaigns. So, anybody else like to say anything or ask any questions?
We've had other discussions with folks about, what is an obligation, what is not. It's understandable if you spend a lifetime, associating the idea of a check with an obligation. I get that. But the language is pretty black and white in the rules and the statute about what this is.
And I certainly can understand, this is not any attempt whatsoever of trying to obfuscate what I was doing.
Yep.
Just because I didn't have the information that
We're not trying to
Hope for
ascribe
respect.
blame or anything like that.
Yes.
Strictly a finding of compliance.
Yeah, and it's also, been my experience in the past, as I've had a past for this, that wasn't the case with me. I was able to get the data and pass it on in a timely manner. So this one, I just wouldn't get the data.
Commissioner Hastings.
I just, when I'm looking at the discussion here, it says that on the day after the report being due, you called Lori on and disclosed that you had an unpaid debt of $6,771.37. That sounds like a pretty definite.
Well, I didn't disclose it per se. I was asked by Lori about that. We were discussing the relationship I had with Frank at that point in time. And I was expressing what I just expressed to you.
In my mind, there's a big difference between asking Frank what various things would cost and placing an order. But the way this is spelled out, it would appear that you disclosed it as an order. Essentially, it was a debt you'd already had.
Well, I think it reads that way, sir.
I know, but in these other cases we've had recently, there's been discussion about when does it become an obligation? When does it become a payment or
reportable?
Or And this is just a,
What I have to clarify this. So when Scott called me the day after, he already had a late filed report. He was 1 day late in filing the report. So during the conversation came, the whole thing of debts and obligations came up. It wasn't clear until 4:30 or later, because I think Scott will back me up on this. It took him multiple calls to get an actual number. He told me that he didn't know exactly what the amount of the obligation was, and that he needed to contact Frame. So literally, it took until 4:30 until he got back to me, and he told me what it was, and I entered the debt for him and refiled that report. So he didn't actually know when he filed the report originally, well, when his treasurer did, what the debt actually was, how much it was. And it's because the debt was that amount. And the only thing he reported was the MCEA payment that made the report substantially incomplete.
Sure. Thank you, Ms. Grant.
it does sound like there had been an order made and there was an understanding that I've ordered something. I'm just not quite sure what it's going to cost me.
Could I comment? I actually don't know the specific facts. If you want to delve into, was there an order placed? Did this really constitute a contract, promise, or an agreement? Was there really an agreement? We would need to get more information from Mr. Caius. I don't, I don't know specific, I don't know what happened. I don't know if you agreed on a certain number of literature, so we just don't. Lori made the assessment, this was an obligation, but I don't know facts in addition to that.
As I tried to point out, for me this time, and I say this time because I have dealt with Frame previously, same issue. They provide, a variety of services, and because it's sort of they lump things together, it makes it easier for a candidate to utilize them, which is why the Democratic Party uses them a lot. And in the past, they've been very effective to my mind. And so I was happy to be able to use them. In the past, though, I've been able to get that information somewhat more consistently, certainly. And I think I had one or perhaps two previously having to amend in a filing. That makes sense to me. In this case, it really felt very different to me with them, that I just was not getting enough information to be able to move forward. I didn't even know, other than the fact that I showed up for a photo shoot, which they said they were going to charge me for. They didn't say then that they were charging me for it, so I didn't even know at that point in time. I couldn't get anything from that, and I was very frustrated by that.
Had you ordered something for them?
I didn't, at that point in time, I had no order. I didn't have any order. As far as I was concerned, I had no order. I showed up because that was background. They said, we're doing a shoot on one day. Everyone's coming that wants to, show up. But I didn't even see that as an order at that point in time. And I couldn't get them to give me any information. So I would, as I said, this is, for me, this time was very frustrating and very different than it was in the past. So that's why that debt wasn't in there.
Commissioner, it sounds frustrating. Mr. Geisen, I have a question. In the staff memo we have, there's reference to, do we reduce this penalty or not? There's general guidance about that with some examples. And you're listed as having previously a late report with a penalty on that. You want to comment on that at all, or should we factor that in or not in our thinking?
Well, I can comment on it. It's kind of interesting. My wife is my treasurer. Her previous husband had committed suicide last year, and she and her son and daughter and their families were going to Scotland to put his ashes and his father's ashes in Scotland. That was part of the family grieving trip that they were doing. And she was gone at that time. So that became one of the other pieces that I was trying to juggle at that point, because I didn't have her there to be able to do the strict filings. So
Okay.
that's the only other thing I mean came up at that point in time.
Thank you.
It's a confluence of lots of rocks in the water.
Not yet. Okay. No. Any other questions for Mr. Geist? Thank you. Thank you for coming and speaking with us. So now we move to the portion where we discuss what we're going to do, and I will make a motion that we assess a penalty of $135.43. Second.
Mr. Chair, can I just make an observation?
You may.
And especially because you asked me for my legal advice in one of the previous matters about sort of what the job is with these types of matters. And I think one thing, and I think it's somewhat been arisen in the course of the discussion here, although I'm not sure how much in the original appeal letter. It is within your jurisdiction, I think, to review the commission staff's determination as to whether a substantially conforming report was filed. So to the extent you feel that that's something that's been raised in this appeal, you could consider that first prior to the question of whether to waive or reduce the fine. That makes sense.
Thank you. Thank you. But I will note that the report was also filed one day late.
Oh, that's true. Yeah.
So
that's true.
Okay, so it's been moved and seconded that we assess the $135.43. Is there a discussion? Okay, we'll move on to a vote. Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Marvel, yes, Commissioner Newman, and I'll also vote yes. Thank you so much for coming in. Okay. Okay, is Mr. Vanderholst available? I know. I get it. Mr. Vanderholst, welcome back.
Hi, thank you. Thanks for your patience.
What's that?
I said, thanks for your patience.
Of course, of course.
I guess it was my patience more. It didn't take me as long as it took to. Yeah.
When we last spoke, Commissioner Leclerc had asked you how the contribution, the mechanism for the contribution had been made, and you were going to find it out for us.
Correct. Okay, so we confirmed that it was a wire. And it was received on 10/3, October 3rd, which is when we reported it on our report. But we don't have access to, we don't have information on when that would have been initiated. We can't tell that.
I can understand that.
Yeah.
Ms. Leclerc, Commissioner Leclerc, does that answer your question?
Well, I perhaps could use some input from other commissioners on this. Given the nature of the complaint, if the wire transfer was actually initiated a day or two before, would that be relevant to any consideration, any issue that we have under consideration here?
Commissioner Hastings?
Well, I'm not sure about whether a day or two makes a difference, but I would think of somebody before sending a $1.5 million wire, you would let somebody know that you were going to do it. And I would think at that point, that would constitute at least a pledge to make a contribution. So I don't know if they were called the day before and the second to say a wire was coming, if that makes a difference at all in this. But somebody must have, didn't just, I don't check my bank account that often.
Mr. Vanderholst, can you address that? Did you have any notice that this wire was going to be coming in?
Not that I'm aware of. We reported it on October 3rd, and that's when it was received. And the testimony of Mr. Schilling is that there wasn't a pledge or promise before that.
So what you're saying is that your organization had no knowledge before the wire hit its bank that this wire was coming?
Not before October 3rd. It may have been earlier in the day.
Okay.
I don't think it's even possible to see when exactly in the day.
I mean, it all could happen one day too. Sure. You could call in the morning and say, "Oh, I'm sending a wire." You're saying that nobody knew before the 3rd, anyhow, within the organization, that the money was coming.
Well, I can't testify to, let me see what Mr. Schilling says in his statement. Did not solicit funding. Did not commit to any expenditures until after the contribution had been received on October 3rd. Maybe it's in the earlier statement. Not prior to October 1st, no.
Right, if we known it the day before, it made any difference?
So, I mean, our only knowledge of the facts are what Mr. Schilling has seen fit to include, and he has been responding to sort of, I listed questions from us and he's been answering the questions. The fuller context is not really known. And I just want to say, we've offered a staff recommendation, but we're really happy to do more. We're happy to reschedule this. Hearing from Mr. Schilling would probably be the best way to get to the bottom of what the arrangements were, or knowledge or was not. So just to answer your question, if Mr. Klingenstein had made a contract or a promise or an agreement, expressed or implied, whether or not legally enforceable, to make a contribution, and if that contract, promise, or agreement had happened on or before September 30th, technically, that should have been in the quarterly report that we received on, I think it was, I forget that date, but we don't know whether there was a contract, promise, or agreement made before September, made before October 1st. I hope I didn't mistake it. Yeah, by September 30th, if there was that, then it would need to be reported. We don't know if that event happened or not.
And Mr. Schilling's letter under penalty of perjury says not before October 1st, so.
Correct.
You got the 1st and the 2nd, so it's certainly feasible that somebody called on the 1st or the 2nd and said we're gonna send a wire.
Yeah.
And which would have been reported, still been reported on a timely basis.
Right.
So I guess I'm.
And the other thing is not to state the obvious, there's no confusion about where the money is coming from in this case.
Yeah.
All right.
Thank you, Mr. Vanderholt. We appreciate it. So
Thank you.
Are there any other questions for Mr. Vanderholt?
No.
Okay, I'll make a motion then that we suspend the investigation and take no further action on this matter. Is there a second?
Second.
Okay, now it's time for our discussion. Any comments or questions from commission members? Okay, we'll move on to a vote. Commissioner Leclerc,
Yes.
Commissioner Hastings,
Yes.
Commissioner Marvel,
Yes.
Commissioner Newman,
Yes.
and I'll also vote yes. Thank you very much for helping us through this, Mr. Vanderholt, and for taking a little break and finding out the information we requested.
Thank you. Thank you for your time, everyone.
Of course. All right, we'll move on to agenda item 6, which is the proposed legislation. And what do you need here? Do you need a vote or just a yay or nay or?
And we would have to ask them. The amount, there's a question or a request from Mr. Guyson, that the amount that he reported as an unpaid debt was actually a little higher by about $400 than the amount that he eventually paid for him. So he was asking whether instead of the $135 penalty, could the penalty be based on the amount that he actually paid for him, which would result in about a $9 reduction. It would be a $126.83.
That would require a motion to reconsider. Is there a motion to reconsider from someone who voted on the prevailing side? Hearing none, I would say no.
Sorry.
Thank you. So for the proposed legislation, what are you seeking from us?
Well, some sort of statement of approval, whether we, first of all, we only want to move forward with each and every proposal that it meets with your approval.
Yeah.
So if there's anything that you think is not as ill-advised or needs to be changed, we're very happy to do that. We do have a December 7th deadline for all agencies. There's a December 7th deadline that we would like to meet.
A day that will live in.
Yes.
Also my mom's birthday.
But that's not why.
Right,
that's not.
But if you're satisfied now, or you want to make any changes, when you're satisfied, I just think I need some sort of statement of approval. I don't know if there has to be a vote or not, but.
And I don't want to delve into this too much, but I'm just curious, just very generally, can you just tell us the process that, by how you made the, like, do you have to and talk, or these comments that you've gotten from the public, just sort of what, is this issues you've noted throughout the couple of years and kind of been highlighting those along the way?
Yeah, thank you for the question. Yeah, well, no, not so much. Well, I can't think of anything that was originated from outside the commission. One or two of these may have been suggested by Mr. Bolton in terms of the enforcement procedures. So yes, we sort of Martha Courier.
She was trying like hell to keep her name up.
Yeah, was extremely helpful in this, and she solicited opinions from the staff. And this year was more of a democratic process because of that than previous years, because oftentimes I'm sort of overseeing this and a lot of the ideas originate. But I think collectively, yes, we think about things that happened this year, the last 2 or 3 years, and ideas percolate up. And then I do oversee the process. So I don't think I rejected any ideas, but I might have changed them, and some of them were from me too. So that's it.
I got a couple comments.
I do too. I've got comments and questions and kind of some thoughts about whether some of these are advisable or not. I don't know if anybody else does. I just had a wordsmith and that's all I have.
Maybe we should go through them. Or
You want to go through?
Well,
or do you want to talk about the ones you have comments on?
Well,
Sure.
I'll be happy to start off.
Go ahead.
My first question is on page 3. And this is almost a wordsmithing thing, but we're changing on this violation from one that the AG has to take to court to one that the commission handles. So it's no longer a civil violation. The commission can the commission adjudge civil violations?
I think you're right that's
just a
calling it
violation.
a civil violation is
So
probably
now
not
it's
correct.
just a violation. If we took the word civil out, wouldn't that?
Good point.
And my only other real comment.
If you don't mind, while we're on that
got
particular
more?
provision, well,
Yeah.
I was just wondering why you want to set up a whole different scheme for the $250 penalty if it's less than 6 weeks. Why not just leave it as a penalty of not more than $500? You're setting up a whole kind of unnecessary scheme with the $250 in 6 weeks.
I'm trying to recall the rationale for that.
My rationale was that the deadline to file the report is set at a certain date. And then I sent out a letter saying, you didn't file this report, and by law, you have 14 days from when you file the report, from when you get a notice from the commission to file the report. So it's still late, but then the penalty could be not more than $250. We're thinking that if you really just ignore what the commission is asking you to do, what the law requires you to do, then you could get bumped up to $500. We were trying to have a tier
Sort of a
system.
graduated penalty.
Yeah, but it doesn't have to be that way. We could just put it at 500 and let you all decide what you want to do.
That's what I would do. Simple, yeah.
So it is saving the process of going through a referral to the AG and all that.
Right.
Keeping it in-house, as we do with pretty much everything else.
It would be in-house, and it could also, one common problem we have is that people just ignore us. So it actually would be handled at the staff level. And the preliminary penalty would, if they continue to ignore us, would actually become final, and we would, if you're okay being cut out of the process, it would just be sort of a more of a routine matter that we would handle at the staff level. For people who just keep ignoring us, the penalty would become final, and then we would let the AG's office know that it is owed. And that was part of the rationale.
I think that makes a lot of sense.
And the only thing I have on page 3 is a wordsmith. The last section, within 3 business days of a filing, shouldn't it be candidate who?
Yes, it should
Not
be.
candidate that?
It should be. I noticed that as well. The second line of the underlined part.
That's what the revisor's office does.
Right, exactly. And that was
They have
why.
their own rules over there.
Right, the revisor's office. looks at
Damn
that.
advisors.
There's a whole office that will
Right.
check this.
Where's the
grandma.
It may bear no resemblance to what the commission.
Okay.
The candidate's name is who?
Right. Who's on third? I think that's another. Something else that I wanted to.
My next comment's on 6, page 6.
Go ahead.
The disposition of fees that you now want to bring out of the general fund and back to us, I think what we're talking about. Just want to point out, having gone through this when I was in the legislature, this will have a fiscal note. Because the office over there will determine how much less money the general fund will get. And they will put a fiscal note on this, and the bill will not get final passage unless the money is found in the budget to fund it. So what it means is it goes on to the special appropriations table and doesn't get dealt with until the last night, and you gotta find funding for it. Even if it's only $25,000. And I've seen a lot of bills on them. So the way to handle it is either make it a separate bill or get the governor to put this into her budget. Or hopefully it gets through the last night it gets funded on the appropriations table.
Great point. Yeah, way smarter to get it in the budget.
And the other issue you can run into is, when I was on the Judiciary Committee, used to come up with fines. When the courts assess fines, it goes to the general fund. No, the courts like to think of that as, well, we brought all this money in, so we should get, it should be ours. Well, the argument is we don't. Increasing fines, it should not be a consideration of a body such as this to decide to make the fine bigger because we need some more computers. There shouldn't be the appearance that we're doing that. And I think that's why the judicial, all the fines from the judiciary go into the general fund. If anybody, probably the amount is pretty small, probably, so nobody is probably gonna pick that up. But those are 2 potential pitfalls with that section, which means that you might want to break it off as a separate bill so you don't lose everything else over. Although you can amend it out of the bill going forward. Later on, if it becomes an issue. Anyhow, my comments, I have no problem with you using the money. How much money are we talking about? You think?
Well, one of my colleagues looked at tax and party committees and ballot question committees and actually and came up with a total over 5 years that would total 190,000. So that amounts to about 40,000 a year.
Oh, 40.
Although I realize that includes party committee fines, which actually are not part of the proposal. So, but it's somewhere in that range, 25 to 40,000 per year.
And were party committees intentionally omitted from the?
That was intentional on my part. I had earlier described it to my colleagues a little differently to include party committees, but the way the Maine Clean Election Act is written, party committees go into the Maine Clean Election Fund under current law. So I thought I would just leave that alone.
Okay.
So this would only apply to penalties paid by tax and ballot question. Oh, we could change that.
Well, I guess what
yeah.
you just said, this bill would have about a $40,000 fiscal note, something like that.
If this is approved by you, is it okay if we just use our discretion about what avenue we follow?
Well, I don't care how you do it.
Yeah.
Okay.
And I'll second Commissioner Hastings' comments. You made some very wise comments. Yeah.
Thanks for raising that. I haven't thought of that.
It's a little no.
Right.
We happily would vote on millions of dollars of spending, knowing full well that it would go on the appropriation table and die the last night.
Right. Yep. That's one of the great secrets of the legislature.
I just wanted to say that the appearance issue that Commissioner Hastings mentioned is something that we referred to in the legislature. We're aware of that. We think that's manageable. We hope that it wouldn't come up. But if that makes you uncomfortable with it.
Doesn't make me uncomfortable.
Oh, okay.
Well, and
manager.
we've got a general trend over the last 5, 6, 8 years of increased use of clean election funding, more requirements of data entry, of oversight, I mean, there's justification there that's pretty straightforward, I think.
My only other comment is on the last page in paragraph 12A, subparagraph F. I know what we're trying to get at. We're trying to get at the campaign employee who gets paid 30 grand out of election funds. I don't know that describing it as paid to an individual for services rendered is elegant enough to get at what we want. Because I think, if somebody is a printer, you're going to pay them money you're going to pay that person money for services rendered. So I think we need to come up with a better term for that person.
But examples
Well,
of services help.
I'm sorry.
Well, what we're trying to do, there were a couple of campaigns that paid a lot of money, like 25 or 30 grand to a campaign staffer. Who was doing who knows what. We had no way of knowing that. And this is getting at a requirement for those people to report what they're doing for the money that they're receiving, for the public money that they're receiving. This would only require, I think, or only apply to Clean Election Act candidates, correct?
Yes.
Yeah.
I agree with what the chair said about service rendered is confusing. I also, I don't know, I'm thinking about it. The $1,000, was that picked for a particular reason?
There were a range of views on that. That struck me as low, but there was a consensus.
I also note that, 1,500 is the minimum for a person to be considered an employee, for example, in a union or something. So it's even lower than that.
Oh, that's interesting.
Which is, so I would suggest at least mirror, which is right now 1,500.
Oh, that's a great idea. That's a great idea. And maybe you could refer to it as a member of campaign staff or something like that.
Yeah.
Martha, was that going to be your suggestion?
Yeah, Martha had something to say.
Well, you were concerned about the language of individual for services rendered as
Right.
it would compare to like a printer. But up above, we talk about needing to require a person to keep track of things from particular vendors. So I would view a printer as a vendor, not an individual. Does that cover your concern?
No, because I think calling it a payment to an individual for services rendered is way too broad. I mean, I think that's gonna suck in people we can't even anticipate right now. And I'd much rather see it phrased more specifically to get at the member of the campaign staff that we're aiming at.
I think saying that language.
Yeah.
So the previous sentence uses the phrase for providing campaign staff. Is it services? Is that something along those lines? Is that?
If a candidate for legislature pays at least $1,500 to a member of the campaign staff for services rendered, maybe.
Okay.
That would work.
Does that? So
Oh, go ahead.
I have a couple of questions. I mean, I get where the commission is coming from with suggesting individual for services and referring to vendor. I mean, would be helpful. I'm not trying to make this more complex, but is vendor, for example, defined otherwhere in the statute?
It's not.
It's not, okay.
Yeah.
Not in the rules. And I didn't understand the reason for elevating it to 1,500. I didn't hear that.
Oh, sorry. I just was noting that, for a person who's considered an employee, for example, if you pay a housekeeper or a nanny, it's at least if you pay them at least 1,500, that person becomes an employee. So my thinking was at least mirroring that,
I think that's smart.
because it's sort of like now they're an employee of the campaign.
I don't know if I agree with that. I mean, I understand where you're coming from, but $1,000 in Maine Clean Election funds is a lot of money. And I mean, we're not really talking about employees here. They're not identified as an employee. They're simply talking about a single individual who's doing some work for a campaign and has received $1,000. I mean, for example, in a house race, what's the first increment they get? Somewhere around $5,000 or $6,000. And one person could get, a fifth of that. So I think it's more important to look at the context of what we're talking about. This isn't necessarily an employee. It's simply somebody who is getting a significant portion of Maine Clean Election funds. And I think it's good for the public we serve to say, well, where did that money go? What did they do? Who did it go to? And what did they do? I understand. I would kind of like to keep it at the lower level, I'll be honest. Because I don't think the employee comparison is really more important than keeping the public informed about where precious Maine Clean Election funds are going. So, and that's my 2 cents.
That's your $1,000.
Yeah.
Well, we may have a difference of opinion on that. Do we have general consensus about the idea of requiring a campaign staff who's paid a significant amount of money reporting what they're doing?
Yes, for me, yes, I think that's good. It's a good thing to do. Absolutely.
I do too. So we have a difference of opinion on the amount of money. So let's have a vote. Commissioner Leclerc, would you like to make a motion?
Well, I would just like to stick with the staff recommendation of $1,000. So I would move that be the amount.
Is there a second? Second. Okay. Do we need further discussion?
Jonathan, but you're about to.
Well,
say
I'll wait
something.
until after the vote.
No, go ahead, please.
No, I just wanted to elaborate on the question that the chair asked, which is some of you have been around making the election. campaigns are run as Maine Clean Election Act candidates. I just wanted, there could be an objection that this is sort of over-regulation or too much paperwork by, suggested by the agency when there's not that much of a showing of a problem. And I just wanted to make sure that you were comfortable with this from that standpoint.
I'm extremely comfortable.
Okay.
I think it's a tremendous idea. Commissioner Hayes.
The other thing I learned up there. As soon as this bill is filed with the committee, it becomes their bill and not our bill anymore.
That's true.
So they can do anything they want to.
Right.
We shouldn't wrestle around with the, I don't know how many times we sat there and the chairman say, this is our bill now.
Yes.
We'll do what we want to do.
You're exactly right.
Good
Yeah.
point.
It doesn't make sense for us to waste a lot of hair pulling on specifics, but we have this motion in front of us and been seconded. So let's have a vote. Commissioner Leclerc,
Yes.
Commissioner Hayes,
Yes.
Commissioner Marvel,
Yes.
Commissioner Newman.
Yes.
I'll vote yes as well. So we're gonna stay with $1,000. We'd like some better language about whether, to make it clear that it's a commission staff or not a commission staff, a campaign staffer.
You like to use the word commission today.
I know. Well, I want to make sure I'm being respectful to all of you. So, yeah, go
I
ahead.
have one other comment. I want
Yes.
to make. Page 10. Enforcement of penalties. Up till now, if there are unpaid penalties, they can be referred to the Attorney General's office. You've added language that says now the Attorney General shall enforce. Is that something the Attorney General will be comfortable with? Every $50 fine, are you gonna have to have another page 8?
I think it already says something like that, actually. Wait, let me.
This doesn't, this section, it's kind of weird. It just says, if they haven't paid, we can report them to the Attorney General.
Yeah, it already says
Like
shall
reporting
enforce.
them to the teacher or something.
Yeah, the current statute already says that. So
Well, it
you
doesn't
wouldn't
say
be,
you have to file an action though.
that it may be that the red line isn't quite right here because the current statute says the Attorney General shall enforce the violation in a civil action to collect the full outstanding amount of the penalty or order for return of.
Oh, so the changes only up to 3 times.
The change,
Oh,
yeah.
I see. Okay. so
And
that's
I suggested this to John, just based on my experience in trying to collect these. Our office doesn't have a view on this, just to be clear, but I just pointed out that it might be easier to get voluntary compliance if there was a, if
Sure.
making us take them to court had consequences.
Sure. Yep.
So,
Oh,
but
so
that's.
not, some of that language is already there.
Some of that language is already there. The change is that it's now could be up to 3 times the penalty instead of capped by the amount of the penalty. There is one, and I didn't get a chance to see this final language until the other day, but there is one, potential ambiguity in the way this is written, which is that it's not totally clear to me whether the 3 times applies just to the penalty amount, or if it also means we could potentially seek 3 times the unreturned Clean Election Act funds. I think as it's written now, it would apply to both. And I'm not sure if it may be something you want to think about, whether that's what you would prefer, as opposed to just having it apply to the fine. Because I think usually there is both a fine and a demand for return, at least in my experience in the couple of years I've done this, that usually if there's one, there's also the other. I mean, not there could be a fine without a demand for
Right.
return, but if there's a demand.
But
for
in the
return,
real
there's
world,
usually
can't the phrase up to cover that problem?
But they don't have to do 3 times.
That's right, they can, yes. So it would just be a question of whether you wanted to limit the Attorney General's, discretion a little bit. Just throwing it out there, that's all.
Does that feel awkward to ask for 3 times? Like if somebody owes us money back, do you feel it's awkward to ask for 3 times that amount in a court action? Is that, I just want to clear this to you.
Oh, to me?
Yeah.
No, it doesn't, there's sort of process, right? If you are fined by the Ethics Commission, you can appeal to Superior Court. There's a process for doing that.
Right.
This is a situation where you've been fined, you have not taken an appeal, so you're not seeking judicial intervention to review the commission's decision. You're just saying, no, I'm not going to pay the fine.
Right.
And so that doesn't give me any discomfort.
I agree. Yes, Mark.
Just a point of clarification before we wrap up. Earlier today, Mr. Tardy brought up the point of letting commission staff make a determination on ads like Mr. Poliquin's instead of going through the process of coming before you all. And it seemed to be something that you were interested in. Is this something that you want us to draft language and put in with a commission bill this session? Because we're coming up on this deadline.
Yeah, I don't think so. I think.
So we'll wait till next time around.
Well, but it would not be bad to kind of flesh something out and see if we can get the governor to introduce it or something.
Or we could just wait until the next session, you know.
Yeah.
It comes up, just prior to the next election cycle.
Yeah, but I think sooner is better than later. I would not want you to hold this up or to do it and encumber this with that.
Right.
I mean, we
Or we
could
can add it.
easily draft the language. It's just a matter of what the process would be for, you know, do you need to see it? Do you need to approve it? Obviously, you don't need to vote on it. If there's an idea that you want us to move ahead with and draft, we can certainly do that for this bill. We have enough time to do that.
Yeah.
I would like to have it happen not as a part of this.
Agree.
But then if we can have it together to put it in, to get the governor to sponsor it or something, I think that's great. So,
Can you put in after deadline bills, Jonathan? Do you have that authority?
The commission does have a separate, like our unique authority to put in.
well,
Yeah. Because somebody, the
Stacy.
departments can put in after deadline bills by right.
Stacy.
can't they?
I think we need to vote
I'm
on
always,
this really quick.
What?
Before we do any more discussion, can we have a vote on this package of legislation? I'd like to move that we empower Mr. Wayne to submit this legislation on behalf of the commission. Second. Is there any other discussion? With the comments that with the considerations that we brought up. Commissioner Leclerc,
Yes.
Commissioner Hayes.
yes.
Commissioner Marvel. Yes. Commissioner Newman.
Yes.
I'll vote yes as well. And thank you.
Thank you.
Thank you, Commissioner.
Thank you.
Just to answer your question, the commission has special statutory authority to put in legislation within 90 days after the general election. We proposed it and it became enacted. Because out of a recognition that we're very busy and things come up and we might need some time after the election to put in our own bill. So I was hoping to avoid, I just feel like it gets the bill printed and attended to more quickly if we meet the regular agency deadline. But we could put in a separate bill after the deadline through this other authority. If that's what you wanted to do.
I would just, I think I'm initially in favor of the idea of what that suggestion was headed, but I would also like us to kind of convene.
To be able to consider.
Kick it around a little and consider it.
I agree. All right. Super.
Also, there is a redlining process. So I don't mean to take advantage of it, but the revisor's office, I mean, this is within the scope of what has been allowed in the past, is that we could put in the bill as written, and if I bring this up with you in December and you want to move forward with Mr. Tardy's suggestion, when the bill comes back to us for a redlining opportunity, we could
slide it in there.
Yeah.
Sure. Sure.
Don't want to offend
Because I remember all you had to do, I mean, as a legislator, I could just go over and say, I want to put a bill in that makes it illegal to do this.
Right, and somebody.
That's all you had to do was a concept, and then you waited for the revisor to actually try to write it up.
Right, right. Yep.
Well, maybe we'll bring this up to you next meeting and
Perfect.
we can decide how to handle it.
Yeah, perfect. Great.
I'm looking at the clock. May I make a motion to adjourn?
You may. Is there a second to that motion?
Yes.
Hate to have that one fail for lack of a second. There's no debate allowed, so we'll go directly to a vote. Commissioner Leclerc,
Yes.
Commissioner Hastings.
Yes.
Commissioner Marvel. Yes. And I'll vote yes as well. Thank you all. Thank you, everybody, for all the help and for being here.
Thank you.
December 21st, if that's still okay.
Very good meeting.
That's the next meeting is December 21st.
That's right.
That's it. That's it.
Will Santa be there?
Here. Thank you, guys.
Bye.
Always.
Gotta get better, right?
Yeah.
We admire your discretion about some of the customer service type components of your work.
We'll let you read between the lines.